Good afternoon. Welcome everyone to BCLP. I am Shivani Sanghi. I'm a partner in BCLP's disputes team, and I am also the head of India practice for BCLP. The theme of today's event, Two Nations, One Legal Future, could not be more timely. The India-UK relationship stands at a pivotal moment shaped by deepening economic ties, increasing cross-border investment, and growing legal collaboration. As businesses operate across borders with greater confidence and increased complexity, closer cooperations between our two legal communities, between the UK and India, is not merely supporting a commercial activity, but it is shaping the framework of the next chapter between the India-UK legal partnership. It is my absolute pleasure and privilege to welcome you all to this event and to host this event that has been organized by the General Counsel Association of India and supported by the Law Society. Without further ado, I would now like to invite the two co-founders of the General Counsel Association of India, Dr. Sanjeev Gimawat and Dr. Akhil Prasad.
Thank you. Distinguished friends from India and the United Kingdom, and ladies and gentlemen. It's both my privilege and personal honor. It's both a privilege and a personal honor to welcome all of you to this important India-UK dialogue hosted by General Counsels Association of India. I extend my sincere gratitude to our host, ACLP, our distinguished speakers, guests of honors, and every participant who has traveled from different jurisdictions to be part of this conversation. I would especially want to welcome some of the legal luminaries whom I followed over the years. Philip Wood, you are with us. Lord Christopher, you are with us. Many others, Sudhanshu, and shortly we would be having some of the other prominent legal luminaries of the world, which include Jimmy Yim, Gaurav Banerjee. In the end, we would be having Right Honorable Lord Hammer, the Attorney General of India. Jimmy is here. Welcome, Jimmy. We would be having Brett Dixon also as Vice President of the Law Society of India, and many of the prominent personalities, legal luminaries from India and the United Kingdom, which include, of course, Shivani, Karishma, Sharina, Mahesh Agarwal, Pinky, Geeta Luthra, and many others. Today is not merely another conference. It is the beginning of a larger conversation about the future of law, the future of commerce, and ultimately the future of our modern civilization. Today is, well, the world is experiencing today the transformation at a pace unprecedented in modern history. We are witnessing simultaneously geopolitical alignment, realignment, supply chain restructuring, energy transitions, artificial intelligence revolution, climate change, and new forms of dispute resolution. Our global GDP today exceeds over $110 trillion. Our cross-border investment flows exceeds US$ 1.3 trillion annually, and more than 60% of the global trade now depends upon complex multinational legal frameworks. And every major challenge confronting humanity today is increasingly transnational. Yet, Philip, you would agree with me, yet our legal systems largely remain national. This creates an inevitable question: can 21st century problems be solved with 20th century legal silos? And our answer is no. That is why this gathering is historic. Perhaps for the first time, we are bringing together policymakers, judges, arbitrators, regulators, law firms, businesses, academics, general counsels, and so on. And that the objective is that law is not merely a mechanism for resolving disputes. Law is our infrastructure. Just as ports move goods, roads move people, and digital networks move information, legal systems move trust. And trust is the currency of modern economies. Without, without trust, investments do not flow, markets do not function, contracts lose value, innovation slows, and societies become unstable. This event seeks to create a common platform to discuss how legal systems can become engines of economic growth, social progress, and global cooperation. And the themes today, what we selected, is not accidental. They reflect the future architecture of India-UK relationship. The recently concluded India-UK FTA represents one of the most significant economic partnerships of this decade. Today, trade agreements are no longer merely tariff arrangements. They involve investment protection, they involve digital trade, intellectual property, dispute resolutions, and so on. And lawyers and legal institutions will therefore play a central role in translating treaty promises and into economic outcomes. Our planned investments in infrastructure is huge. Our energy transition alone requires trillions of dollars globally. Ports, shipping, LNG, green hydrogen, renewable energy, logistics corridors, and all require legal certainty, and capital follows predictability, and predictability follows law. Our global arbitration continues to expand rapidly. Businesses increasingly seek neutral, efficient, and enforceable mechanisms for resolving disputes. India and the UK possess an extraordinary opportunity to collaborate in creating dispute resolution systems that are faster, technology-enabled, and globally trusted. Artificial intelligence may contribute more than $15 trillion to the global economy in the next 4 or 5 years. The challenge before humanity is unprecedented. How do we regulate technologies that evolve faster than legislation? This requires cooperations among jurisdictions rather than fragmented approaches. And that is why the whole structure of our today's conference, and we don't say that this is just merely a conference of that discussion. We want to set up some benchmarks from this discussion onwards, and that how we want to achieve what we want to do about the business community. Let's accept this reality that today and tomorrow and the 21st century, this is the world of business. A world of business necessarily means the world for prosperity of people. Now, historically, nations competed through military power. Today, nations increasingly compete through legal infrastructure. The jurisdictions that provide certainty, predictability, enforceability, and transparency will attract capital, innovation, and talent. Yet, fragmentation imposes enormous costs. Different standards, different regulations, different compliance requirements, and different enforcement mechanisms. And the result is friction. The future requires not uniformity, but interoperability. Just as technology operates through common protocols, legal systems must increasingly operate through common principles. This is where, Mr. Wood, I would again like to quote you, that your work becomes particularly relevant. For decades, you have argued that legal convergence is not about surrendering sovereignty. It is about reducing unnecessary friction while preserving local identity. The future of commerce demands precisely such an approach. Throughout history, prosperous nations have rarely emerged without strong legal institutions, and there's a direct relationship between rule of law, investment flows, economic growth, innovation, and social stability. But today, we must think beyond a national prosperity. Climate change does not recognize borders. Cyber threats do not recognize borders. AI does not recognize borders. Global capital certainty does not recognize borders. Therefore, prosperity itself has become interconnected. The prosperity of one nation increasingly contributes to the prosperity of others. And the future is not a zero-sum game. The future is a cooperative game. The question before us is not merely how do India and the UK prosper. The larger question is how do legal systems contribute to the prosperity of humanity? And there we are at GCI, and our vision is Global Forum of Legal Professionals. At GCI, we believe the time has come to create a truly global platform, a platform that brings together judges, governments, regulators, arbitrators, businesses, academicians, general counsels, and so on. Because no single stakeholder can solve these challenges alone. And our vision is simple: to build a global community committed to strengthening legal systems as enablers of growth, innovation, and societal goods. For too long, legal professionals have been viewed as risk managers. The future role of legal professionals is much larger. We are architects of trust. We are designers of institutional resilience. We are facilitators of economic development. And increasingly, we are custodians of ethical governance. And in the end, of course, I have written some speech or some contents on this. And the reason why I didn't want to miss these points is that is what the whole theme of today's discussion is. So I may take another 3-4 minutes, but then bear with me on this. India-UK relationship possesses a unique legal foundation. India inherited and adapted many principles of English common law. Our constitutional framework, judicial traditions, commercial laws, and professional institutions share deep roots. Yet, India has not merely copied English law. India has evolved its own jurisprudence. In many areas, Indian law has consciously diverged. Just to give you two examples, law of damages, the way in which it's written, following the principles of English law, and when we adopted the Indian Contract Act, today, the law has just evolved. It's not the same thing what is written in the Indian Contract Act. The law of indemnity, what is written in section 124 of the Indian Contract Act, perhaps copied from the English law. But are we interpreting the law of indemnity with those wordings of Indian Contract Act? Answer is no. So, and there are many divergences. We have adopted English law, but then there are divergences, and those divergences happen. Those divergences happen not today. They happen immediately in the next 2 decades of 1872 Indian Contract Act. By whom? By those British judges. Because the society was not ready at that point of time that in a landlord or tenant relationship and where there is an imperfect market, how would you be having those kinds of concepts in your law which would, in a way, adversely impacting the common masses? Now, that was the reason why those concepts got evolved. What we have written in the codified law, that's not being followed today, and which include from law of indemnity to penalty to liquidated damages to specific performance. We are much ahead on the specific performance. Specific performance and the English law is based on what? It's based on equity. But then we have codified the specific performance. So we have another concept on public interest litigation. Now that's again for the societal goods. So we have diverged on many areas, including on the constitutional reviews to insolvency frameworks and so on. So these examples, they demonstrate, in terms of important truth, that legal systems can share roots while evolving differently. Convergence, therefore, does not mean uniformity. It means learning from one another. And so at GCI, our global ambition is, and that is what today we are starting. We are starting our journey that extends far beyond India. Our aspiration is to create a platform that will be present across jurisdictions, a platform where legal leaders from every major economy can engage in meaningful dialogue. And in the times to come, you will find GCI building bridges between East and West, between developed and emerging economies, between business and government, between innovation and regulation, between commerce and justice, because the future requires collaboration, not isolation. And as we are approaching 100 years in 2047, we have an extraordinary opportunity. The question is not merely whether India becomes a developed nation. The question is whether India contributes to shaping a new global legal order, an order that is more inclusive, efficient, innovative, sustainable, and accessible. The UK, with its global legal influence and institutional strength, can be a natural partner in this journey. And together, India and the UK can help shape legal frameworks for global investment, digital commerce, AI governance, climate transition, and so on. And the significance of our partnership, therefore, extends far beyond bilateral relations. It has global implications. Ladies and gentlemen, history teaches us that great civilizations are not built merely by economic power, they are built by institutions. And among all institutions, few are more important than the institutions of law. Law creates trust, trust creates investments, investments creates prosperity, and prosperity creates stability, and stability creates the conditions for human flourishing. And let us now, from this discussion and the discussions which we would be having today, let us start building a public opinion in terms of somewhere business needs convergence. Business doesn't need multiple legal systems. We operate throughout the world. We cannot have multiple contracts and which would be subject to multiple interpretations. We need somewhere convergence. And so on behalf of GCI, I once again welcome all of you. And thank you for joining this historic dialogue. I wish the conference every success, and I look forward to a stimulating and forward-looking discussion. And thank you very much for being here. I would request Dr. Prasad to share how we have initiated our journey and how we are progressing. And thank you very much. Thank you.
So, hello, am I audible? So Sanjeev and I, we have been partners in crime for almost 30 years now.
Yeah.
So when we started our career, and we started from the same group, which is the Modi group, the Xerox, what we know of today. And since then, it was our dream to create something worthwhile. So I will spend a few minutes about telling you about what General Counsels Association is all about. Yeah. So please pardon me, because the presentation that you see here is 3 a.m. presentation. So it may have a few aberrations because my full-time job is with Boeing India. I'm Boeing India General Counsel. But GCAI is a passion. So that's why I was doing it at 3 a.m. So this so we created, so we are very clear. We are not an event manager. We are not a conference, organizer. As Sanjeev mentioned, our goal is to create and promote dialogue. And dialogue is the only way where you can improve. And we believe that there are a lot of inefficiencies in the system. And I studied in Merit, and I am from Merit University. Sanjeev is from Jodhpur University. We are not the privileged ones. We are not the ones who often come to London. We never were such people who used to come to London and attend events like these. And we realized that there is a lot of anomaly in the system. And the like-minded people, the 9 founders that you see on the screen, is where we all got together. And we thought we should create an association of general counsels. And the idea was not to create events. So what I call the anomaly in the system is about the underprivileged. And the underprivileged is the general counsel. Underprivileged are foreign firms from the Indian context. And underprivileged are the students. And why I say so is because General Counsel is neither a barrister nor a solicitor in India, and therefore not a lawyer. So the real shock came to me when I was on a panel like this in India, and we had a High Court judge on the panel, and we had 4 other advocates, and I was the 6th person on the panel, and I was introduced by the High Court judge as the only non-lawyer on the panel. So that was a rude shock, and we said, so I said, technically, ma'am, you are, and she was a lady judge. I said, madam, technically you are absolutely correct. But the issue is we deal more diverse law than you do, more than any advocate, because the kind of work that we do in a corporation has no limit, no boundaries. As Sanjeev said, we are not only dealing with Indian law, we are dealing with international legal issues, but we are not lawyers. So that's the anomaly 1. Foreign firms, from an Indian context, completely ring-fenced, you cannot come to Indian practice. But what we believe, that a foreign firm and participation of foreign firms in India is absolutely critical. Because when we are talking about a Viksit Bharat by 2047, how can there be a Viksit Bharat international business without international law? So that is anomaly, another anomaly. And another important thing is, if foreign firms were to come to India, it will only enrich the employment opportunities and a better legal landscape. The third and the foremost thing, the anomaly in the system is we all talk about future, but who thinks about the interests of the student? Are the regulators thinking about what quality internship should be provided? We are restricting foreign firms to come to India, so we are not building the environment and the infrastructure for these students to operate seamlessly. Why should an Indian student be only come to London or New York? Why not the similar environment be also be in Delhi or in India? And why only in Delhi, the different parts of India? So that is what I believe is an anomaly in the system. So what do? Do you only write white papers? Do we only tell government that this is how it should be done? And we realize that we have given numerous white papers in the past, and I'm sure many foreign firms have given many white papers in the past. But these things will not work. The government wants action, and we thought that, yes, white paper is important, but more than that, what is important is the kind of work that you do in India. And that is what is more important for the government of India. So what do the partnerships mean? So what the GCAI did, we formed GCAI in 2022. And this was very, very recent. So we did MOUs with most of the big law schools in the country, because we wanted to get the student interest in the forefront. And then we also sought support from foreign firms. And some of them are here, they will be here on the panels. And then we said, let's try to do a few things which will build a better ecosystem in future. And when the government will look at it, the kind of work that we do, that recognition will come automatically, whether to a general counsel being recognized as a solicitor and for the foreign firms to operate in India. That is how we believe it will work. So we have done numerous events in India. There are so many events that we have done. So we started first to build about a consensus. So we did events in Bangalore, we did events in Bombay, we did events in Delhi to gauge from the participants what is it that GCAI should do. And the common thread for them was, yes, foreign firms we should have a participation. Yes, we should think about students. And then we did two national level events. The first event was done on 31st of January 2025, which was supported by Meghwalji, where we talked about the rethink, redefine, re-evolve, and it was about the legal profession in India, what it should be, what Sanjeev mentioned about. The second national level of event that we did was on 19th of September, which we have now created a brand called Nyaya Nirman. And then that Nyaya Nirman is how do we do the nation building? And we discussed the similar issues at our event at Bharat Mandapam, which was blessed by the Corporate Affairs Minister, Mr. Harsh Malhotra. So in terms of government support, we have been able to generate a lot of interest. And there you see the various firms, the foreign firms who have supported us on these two events. And we are very grateful. We want that this should only continue and evolve. This is something which is we are very, very passionate about. And we believe that India lacks a very solid internship and a mentoring system, especially on the corporate side. So when a student writes to me on LinkedIn that I want to do internship with Boeing, I have to coolly say that we do not provide internship anywhere in the world. So is that the answer I'm supposed to give to a student who's looking to learn aviation in India? The answer is no. So, but does it restrict us from creating a forum to create a platform to provide those kind of internships? And that is exactly what we did this year. In January, for 4 weeks, we got students across India from 21 law schools, 119 students under one roof, where we got about 45 corporations, we got about 70 speakers. We took these students to the Supreme Court of India. We took these students to the Parliament, Indian Parliament. We gave them industry experience. And so we created a Nyaya Nirman, September, we created a book on Nyaya Nirman. Now we are going to create a book on Yukti. And Yukti is what we call in Hindi, it's a Hindi word for intellect. And this intellect is what we have named our internship program. And we are going to come up with a 20 volume set. And we are going to do another event next year this year where we are going to initiate. So this is our first step on international work, what Sanjeev mentioned about. And why we want to do this, because I will show you some more slides. This is what we are planning to do, in the immediate next few steps. So perhaps, an event like this in Singapore. Then we will do a September 11 Nyaya Nirman 2.0. Then we will do another internship program in January. But the goal is when we create a forum like this, where we have participants from UK, where we have participation from Singapore, we create a international pool and we do another event at the World Economy. So my immediate task as a secretary of GCAI, once we go back, is to get a venue at Davos. And the idea is to continue this kind of a dialogue at an international level. What I firmly believe, recognition will come not by writing white papers, not by only crying before the government, but to create some solid good work and convince the government that this is the General Counsel, these are the foreign firms who need recognition and be allowed to practice in India. So that's all I had for today. Thank you so much.
So starting with our first session, and which is on strategic partnerships and investment corridors, enabling the next wave of India-UK growth. The themes for today's discussion is India-UK FTA legal implications and investment protection, infrastructure, ports, logistics, energy transition, collaborations, green hydrogen, and so on, and strengthening bilateral investment frameworks, legal predictability as a catalyst for capital flows, institutional dispute resolution, prevention mechanism, and cross-border regulatory coordination. So for this session, we are blessed. We are blessed with some of the people who are not only brands in themselves, they are the real intellect which the world has produced. Unfortunately, I think Lord Krish Raval may be perhaps joining us late, but then Mr. Rakesh is here. Yeah, perfect. I think he may come later, perhaps, after getting free from Parliament. Yeah, yeah. Okay. I'm just, inviting in order of alphabetical names, Babita. Babita is co-head of India Group CMS. I'm absolutely privileged, Babita, come, that Lord Christopher is with us. I had a detailed chat with Lord Christopher. I was so impressed with him. He knows India more than me. And he is a real architect in terms of the thoughts on the India-UK relationship. Grateful, grateful. Kristen Graham is a partner from Kristen. Oh yeah, Kristen. Welcome, please. We have another intellectual here, and his name is Jimmy. He is, again, in these centuries, those are very few names who are having the knowledge on disputes resolutions, the philosophy, and so on. And Jimmy, I'm highly grateful to you. You have traveled so long from Singapore to here, and highly grateful to you for being with us. Then we have Seema. Seema is a close friend. We are in disputes against each other because we represent different organizations. But then so kind of you that you came from Mumbai and all that. So nice of you. Thank you. Thank you, Seema. And in the last, I would be inviting Akesi, Mr. Sudhanshu Swarup, whom I know for perhaps over a decade or more than a decade. He is the real name on dispute resolutions, and particularly when you are talking about bilateral investment treaty disputes. He is amazing. He is everywhere. All global major disputes are being handled by Mr. Swarup. So nice of you, so kind of you for being here. So, with us, Rakesh ji is here. He is the real man who has done so much of research on bilateral investments and bilateral issues. I would request him to moderate this discussion and so kind of you for being here.
Thank you.
Thank you very much.
Wonderful. Good afternoon, everyone. I am probably the only non-lawyer here, but I tell you my background. I'm in finance, worked there for many years, lived across the world, New York, London, and I have worked with many lawyers. The second to making money is keeping it, and all the lawyers I've ever met have helped us to keep the money in the financial industry. So we really have a vested interest in making sure that this bilateral agreement that we have here works. I'm here today because Lord Raval in the House of Lords was unable to attend in this hour, in this moment. There was a debate timetabled on artificial intelligence. And it has been so popular and it's such a key ingredient for what we have in our society today that they've been debating non-stop since 10 a.m. this morning. And yet Lord Raval still yet has to speak because I think 50 speakers went before him. But as soon as he's finished speaking, he has promised to come here. And he is really a big fan of everyone here. And we have such distinguished guests and such a wonderful panel. So I won't waste any more time. I'd go straight to the panel. And maybe it's because it's a little bit new to me and to some of you. If I could start at the top of the table, if you could please introduce yourself. If you could take a microphone from the desk here. And you have one, perfect. And just tell us a little bit about yourself. And then we'll work down the panel that way. So first of all, let's have a look. Sudhanshu.
Good afternoon, everyone. Thank you to Sanjeev for that introduction. I can assure you I'm not literally everywhere all at the same time, handling all disputes. It's a real pleasure to be here. I'm a barrister in practice at 20 Essex in London, and I practice a mixture of international arbitration, general commercial and public international law, including various India-related disputes.
Thank you.
Hi, everyone. I am Babita Ambekar. I am a partner at CMS, which is actually just across the road. I can see the office from here. I am a transactional lawyer. I have been involved in the India corridor for many, many years. Approximately half of what I do relates to India in some shape or form. In terms of sectors, I have a few sectors that I am more interested in. So technology, renewables, consumer, and life sciences. But I am generally sector agnostic when it comes to India, and have supported on a wide variety of matters.
Thank you.
So I'm Christopher Bellamy. I'm a barrister by background and I'm also a former judge. I've had a lot to do with India over the years. My family was concerned with India for many years. My mother was born in Bangalore. My own time, I was quite involved in the setting up in India of your competition law regime with the Competition Commission and the tribunal, based partly on UK practice. And I was particularly glad to be invited here earlier this week by Sanjeev to reaffirm the solidarity between the UK and India. And in particular today, and I'll say a few words about it in a moment, to support the work of GCAI and of in-house counsel, which is so critical to our joint futures.
Thank you.
Hello, everybody. My name is Christine Graham. I'm a partner here at BCLP. My practice is in antitrust. So by background, I work predominantly in merger control and transactional antitrust work. But an increasing part of what I do over the past 8 to 10 years now is in foreign investment screening regimes. So you may be familiar with the Indian screening regime. Well, I do that times 50 across the world and increasingly advise on companies investing in other jurisdictions on what their FDI screening requirements are. I'm delighted to be here today and to talk more on that subject.
Hello, good afternoon to everybody. My name is Jimmy Yim. I'm very, very happy to be here, to be all of you, but I might be the oddball out from little Singapore. I mean, this is about India and England, or United Kingdom, but I've had involvement in both countries. I had a brief working spell here in London over 40 years ago at the Aldwych. I still remember that fondly. And then I do a fair bit of work in India as well. And of course, in Singapore, little Singapore, we've got a lot of British barristers at our doorsteps because international arbitration is the thing happening in Singapore. And of course, the Indians file a great number of arbitrations in Singapore as well. And India is moving ahead to improve all their systems that they aspire to be an international arbitration center themselves. And I think they are going in the right direction. Speaking on another note, the firm I represent as chairman, we are established in 1889 by two English solicitors, John Drew and Alfred No. So, but since then, we've grown into a fully independent Singapore firm, about 300 lawyers in little Singapore, but 900 lawyers in ASEAN because we represent the ASEAN region of 11 countries. And lastly, in respect of the 3 underprivileged groups that Dr. Akhil is talking about, is quite a little cute little title to call them underprivileged. I happen to have worked with all 3 of them, so I know a fair bit about general counsel. In Singapore, we have 2 general counsel associations, the Association of Corporate Counsel, which is, I think, American-based global, and the Singapore Corporate Counsel Association. Then in respect of foreign firms, Drew and Napier was previously in a joint law venture with Freshfields here in London, in Singapore. That's a number of years ago. And then thirdly, with respect to students, I've worked with the Chief Justice in Singapore. We produced a report on the importance of mentoring students, law students, in the system to make sure that they follow the right traditions. So I'm very happy to be able to touch on all topics. Thank you very much.
Seema.
Good afternoon, everyone. First of all, thank you so much, Sanjeev, for inviting me on this such a esteemed, privileged panel. So really, thanks for this. Very nice presentation of yours, and a lot of areas where we need to think as a general counsel. So to start with, I'm a general counsel of Nara Energy, and we by design we maintain a low profile because we have to work with everyone around the world. So that's how we do. I started my career as a hardcore patent professional, diverse practice in the US. From there, so pharmaceuticals for 13 years, a hardcore practice around the world. And from there, I moved to agrochemical, one of the largest multinational from India. It's called UPM. Again, 140 countries around the world, did a lot of work. From there, now into petrochemicals. So it's a third industry for me in this 20 years of career. And here, Sonara Energy is the largest private sector, oil and gas company from India. So doing a lot of work, interesting work over here. And we're very glad to share my insight, when we do such kind of, commercial transactions and things, how do we do this? Thank you so much.
Wonderful. If we look at the three big areas, finance, energy, and pharmaceuticals, there are some others too. Maybe I'll start with Sudhanshu. What outside the free trade agreement do you think is the legal framework for investors, be they state, be they supranational, the dispute settlement between India and the UK, if we take into consideration the protection of their relative respective investors? So when we're looking outside the free trade agreement, how do you feel about that?
Well, the principal instrument has been the bilateral investment treaty between the UK and India, which was entered in the mid-90s. So at the beginning of the 90s, you had seismic global events triggered by the fall of the Berlin Wall, and suddenly a host of states coming onto the international scene, competing for international capital investment. And the theory was that entering these treaties, which were supposed to provide a form of protection for inward investors, would attract investors. For those who are not familiar with treaties, in essence, they are agreements between states under which each state agrees to provide certain basic protections to the investors, meaning the private companies of the other state coming in. For example, an agreement not to expropriate the investments of that company. That was the theory. The particular twist to these instruments is, although they're treaties entered in public international law, they contain arbitration clauses that can be invoked by these companies to sue states directly in international arbitration. And the scope and ramification of these documents was perhaps not really appreciated at the time, but it certainly resulted in several high-profile claims against India by inward investors. One of the first was a claim brought under the Mauritius India by BIT concerning the Dabhol power station. It's a case I acted on as a junior barrister, and that also involved it was GE, Bechtel, and the Ghost of Enron together suing India. That was one of the first. Then you had retrospective tax claims by Cairn and Vodafone against India, basically complaining that India had retrospectively changed the tax regime. Again, very high profile claims against India. And then critically, you had the White Industries case in 2010, when a tribunal under one of these treaties held that where White Industries, an Australian company, had obtained a normal commercial arbitration award against India and had tried to bring it to India to enforce, the fact of inordinate delay in the Indian court system could itself amount to a breach of the relevant bilateral investment treaty, which was a real wake-up call. And another one of these I'm currently actually involved in is the Davis Antrix matter, which is, amongst other things, ended up in the English courts. That was another bilateral investment treaty claim. But the critical point was that in 2017, the Indian government had had enough and said, we are going to terminate these treaties because we don't want to be sued anymore. Although they terminated in 2017, under the sunset clauses in the treaties, investments made prior to 2017 can still be sued. There can still be claims up till 2032. But the net result is India now has a new model BIT, which waters down these protections, and which it's looking to enter a new generation of treaties, but on these very different terms. So that's the story up until
Sure.
yeah.
Yeah, maybe I could ask Babita, to what extent do you think the legal predictability is playing a role in this type of investment? And do you think that further cross-border regulatory coordination maybe could benefit a wider suite of cross-border infrastructure initiatives? And do you think that could play a part in actually resolving some issues which are stand?
Yeah, so I think legal predictability remains probably the #1 consideration when investors are considering an entry into India. And it's the biggest question that they ask me. So if I'm going into this market, it's a market I'm not familiar with. It's a market that's based on common law principles, but it seems to be a very litigious market. That there is a lot of movement when something doesn't work out as an investment. So people, there is a natural nervousness or hesitancy about entering India, partly because of lack of familiarity, but also because of lots of information being circulated about lots of different issues, and you touched upon a few of those. So I think legal predictability is actually going to be key in how things evolve, and that perhaps also Sanjeev touched upon the bringing out the common threads and sort of making things a lot more consistent. And I think that is incredibly important, and I would be very interested in seeing what the thoughts are on that conversation actually, because I think that presents the biggest hurdle that we have. What do I think we can do on that front? Well, I think greater conversation is incredibly important. Perhaps what we can do, often you'll have country A and country B, and they all have their own infrastructure and their own concepts, and they don't talk to each other. And we talk a lot, but perhaps what we need to do is have groups within these jurisdictions that are trained and fully appreciate how to traverse the gap. And I don't know how that, again, I would be interested in hearing from this room ideas on that. But to me, having that second layer of expertise that can be brought in, whether it's on a transactional front to help facilitate something, or whether it's on a mediation front to help resolve an issue. But it strikes me that is going to be incredibly valuable in this journey between India and the UK.
It's interesting because the relationship between the UK and India has lasted for decades longer than even my first grandparents when they left India, South Africa in the 1900s. Maybe, Lord Christopher, you can maybe speak a bit about the convergence, because in one sense we have a divergence, but maybe we need to re-establish and come back to like a legal convergence in both understanding the nature of the contract and the dispute.
Well, I think we have jointly a very great advantage, which I'd like to speak about in very high-level terms for minutes, which is our tradition of the rule of law, how critical the rule of law is to everything that we're talking about today. In the Constitution Committee of the House of Lords, which I sit on, we've just finished a long inquiry and published a report on the rule of law, which we've called the rule of law between tyranny and anarchy. Tyranny, on the one hand, is the defense of the citizen and of business against power and the state. But anarchy, on the other hand, happens when the ecosystem that governs our daily lives starts to fall apart. We can't enforce our rights when you can't enforce contracts, where the general citizen feels the law is not on his side. So the rule of law has got those two aspects, and they're both very important. And I would say from the point of view of both countries, particularly India, the rule of law, which is under pressure in various parts of the world, and we see with alarm what is happening in the United States, for example, it is absolutely critical that we hold to those long-standing traditions. It's not just a question of democracy and liberty and all those things that we believe in, It's the question of facilitating investment, facilitating commerce. As Sanjeev emphasized, trust in the legal systems and in the people who are responsible for it. And if India were, I'm sure it won't, if India were to ever compromise on the rule of law, you can forget about 2047 and all it stands for. You would be down the drain. And that is a critically important message. What I'd like to do a little later in the discussion, if we have the time, is to concentrate particularly on the role of in-house counsel in this respect. Because you're not underprivileged at all. You are the front line. You are the shock troops. You are the first line of defense for the rule of law, and you come under enormous pressures. But let's come to that in a moment.
Wonderful, wonderful contribution. Speaking about that, Christine, maybe you can talk about two things. One is a question I had from you, and one we spoke about earlier. What is the architecture of the future for FGM screening? Because it's a complex topic and there's so many issues. And many regimes have already proliferated across the globe. Where do you see any convergence with that?
Thank you. Yeah, you're right. Today, in today's landscape, we're facing heightened geopolitical tensions. And what we are finding is that the last 10, 20 years, there was this theme of open investment, encouragement of investment. But now jurisdictions around the world now are looking very closely at protecting national treasures, looking closely at their sovereignty, and there's an increasing tension between this pro-growth agenda while also protecting national security and economic security interests. And many regimes now in the US, for example, the UK, Canada, they have all come forward and said that national security is the same as economic security. And they're looking now through the lens of supply chain resilience, because that obviously is an issue that came out through COVID, and they're looking at de-risking supply chains, so diversifying with partners throughout the world, and also looking at the resilience, why they can become more resilient. So there's this tension, as I said, between the growth agenda, because we all need growth, we need investment, that's the thing, but at the same time, there's this concern about how vulnerable a jurisdiction can become to potentially hostile actors. Either that's through technological leverage, where they can acquire, through cybersecurity, for example, or using AI technology. There could be risks associated with that. So we have these regimes now, for example, in the European Union, 10 years ago, there were 12 member states with investment screening regimes. Now, all 27 have screening regimes. Previously, it was not a mandatory requirement, but now going forward in the EU revised regulation, it is a mandatory requirement now. And again, the number of sectors and scope is evolving. So previously, it would have been military, dual use, defense. But again, because what is national security is an evolving concept, it's increasingly the number of sectors and scope include critical infrastructure, energy, semiconductors, critical minerals. It's expanding. So I think now there is this, I think what governments are struggling and what investors have to deal with in terms of predictability is navigating all these different regimes, because there is no harmonious approach to them, because national security is a national issue after all. And so it's very hard to consolidate that among member states and across the world. But what we are, the intention would be perhaps in the future, there will be more coordination and more partnership with allied countries, and maybe through these systems working out thresholds where we can have relationships with partners that are trusted and that they can work with. But at the moment, we're not there yet, the number of these.
Wonderful. And if anyone in the audience has some thoughts or they have a counter argument, we have a superb, brainy set of panelists. So I invite you all, just put your hand up. I'll take questions from everyone because I want it to be interactive. So you can also have some questions that you have in mind. But saying with that, Jimmy, you come from a place that is so well respected in terms of so many ideas, and it has for a long time been a real success story. I mean, like, we have a huge backlog of cases in India. I mean, somebody gave me a statistic earlier. I forget how many. 50. The numbers are so vast that I stopped counting during the conversation. I mean, and the mechanisms to resolve them. What lessons do you think you can bring from the position you sit in? Because if we apply the same solution, the same old solutions to these new problems, maybe we might end up with a result we don't want. So where do you think the learning lessons have to be right now? And what are they?
Thank you very much for that question. I'm not sure if I'm fit to be able to speak as to what remedies or solutions ought to be offered to India to resolve the 50 million outstanding cases. And there was a study done, I think it was by a leading accounting firm, I think about a few years ago, of the Indian backlog in cases. And they say that if you didn't file a new case tomorrow, you still need about 200 years to resolve the backlog. I was astounded by that. And that was in some official report. But anyway, I'm not fit to talk about what solutions are, but I can share a few experiences of how Singapore dealt with its backlog. So to start with, the reason why we are constantly reinventing ourselves and innovative is that we are actually very nervous about how small we are. I live in an apartment on the 42nd floor in the middle of Singapore Island. And when I look out of my balcony on the north, I see Johor Bahru, the southernmost town of Malaysia. When I look out of my balcony on the south, I've got balconies left and right, I see Batam, the island, Indonesia. So can you imagine? From my own home, I can see the two countries bothering me. So because of its smallness, its lack of resources, the people of Singapore and the government of Singapore is very mindful that we need to constantly be relevant to the world if we are to exist. Because we are bordered by two great nations, great in terms of size, population, but we have higher GDP than they have. I know, that's funny. So because of that, we constantly reinvent ourselves. And you might have heard in Singapore, we create hubs of all sorts. Like, for instance, how the international litigation and arbitration scene became focused in Singapore is because the government decided to create a legal hub. Before they were a legal hub, we had created a financial hub to copy Hong Kong. And then we created a hub for bioethics, germ technology, stuff like that. So constantly trying to do. And I remember when I started practice about 40 years ago, we had a backlog. When I appeared in a case, it was, and I was a new lawyer, about my second year of practice, and handed a case to resolve in court. And the trial was over facts that took place 7 years ago. And the second Chief Justice was specifically appointed by Lee Kuan Yew to solve the backlog. We had a backlog that went back 5 to 7 years at least. And so the government established KPIs through the courts that cases filed must be cleared within 1.5 years. Now, that kind of, the difference between Singapore and many other countries is not that the other countries lack laws. I know, for instance, that there are laws in many countries that says you must write a judgment or you must clear a case within a certain period. The question is enforcement. Singapore is extremely strict about enforcing. Once they decided to do something, they make sure that the rest of their machinery see to it that it's achieved. So that level of focus on enforcement is one feature of Singapore that few know outside of this if they don't live in Singapore. So we cleared the backlog in the space of 1.5 years. And today, we've created a hub in the legal sphere of not just having cases heard quickly, but that we lapped onto it international arbitration, which only started in 1991. I still remember when we started the International Arbitration Center. Okay, this is just on Chatham House rules, okay? We put the chairman of the SIAC as the retiring attorney general who served the country faithfully for the last 27 years. We're going to have to find him a job. So we put him there. And for the first 10 years, we had hardly no more than single digit of cases filed. But then with successive new persons coming in and the relevance that we could play as being a very neutral region ground for others to bring their disputes, that grew. And today it's the leading international arbitration center in Asia, piping Hong Kong. And we're only standing behind Paris and London. But Paris and London have had their game for more than 100 years. So we really just caught up. We're very fortunate for that. So if you ask me how ought it to be cleared in India, I would say that to start with, I can understand why commercial organizations take their disputes on domestic arbitration, because there are enough of retired Supreme Court judges and senior advocates happy to hear the case faster to clear problems. And so you find commercial cases, I believe, in India cleared through domestic arbitration and not through the court system. But then you can't speak of the non-commercial cases, the interpersonal differences, the fight between neighbors, that get lagged on for years, which is unfortunate. I think, and there are 2 million lawyers in Singapore, in India, I believe, right? That's the number. 2 million lawyers in India. And there are, I think, in the Indian administration system, a few hundred judges, but appears that it is not enough. If you ask me, possibly technology and AI is probably the place for the Indian judiciary system to focus on streamlining things. They may have to get lots of their documents and lots of their evidence streamlined and easily digested through AI, and that might help to speed things up. Right now, I think it takes, and there are many Indian lawyers in the house, please correct me if I'm wrong, not intending to embarrass anybody, but I think it takes something like about 10 to 15 years for a case to clear the system. And part of that problem is, I think, there's just too many levels of appeal, too many levels of review. After the end of the appeal, there are reviews. So I think that might be creating more levels than is necessary. But having said all that, India is an incredible country. I love it. Thank you.
Wonderful. Thank you very much. So if I put my finance hat on, if anybody's looking for investment, I'm going to start a new enforcement organization in India to force them to get through their cases. I think that's where the money is, according to me. It's right, enforcement. But maybe I turn to Seema. Perhaps because I know that we spoke earlier, you have a lot of answers. Do you have any answers for any of the questions we've posed already on the panel that you'd like to pick up, or would you like to start thread? Because it's very interesting that the convergence, whether we can use technology from a corporate side, whether you want to see another major push in a particular direction, what would that be to speed things up, to make things more efficient, and to make sure that the agreement works?
It's quite a broad, aspect. So basically, I actually wanted to address one point in typical intellectual property rights, especially from UK, India, FTA partnership. It does talk about it, very clearly. It has a full section on that. But some of the thing which from my private practice and working globally in different organizations, what are the practical aspect of things which still hamper, our thought process and enforcement issues. And typically as an in-house, we do deal with only practical issues, because we can draft a very wonderful contract. We can do a lot of private equity investment we bring, but to take one approval, be it Competition Commission of India, and to talk about FDI, it's an automatic route or a government approval route. So all those issues keep on coming, and we do try to maneuver how do we handle. So coming back to this IP aspect, of course, India is already a kind of well-developed jurisdiction, right from Paris Convention 1883 to, typically Bern Convention, Madrid, all of them are like India is signatory to all these conventions. So it is very much present there in the country. But when we did this UK FTA, the legal text of UK India FTA thing, when it talks about compulsory licensing, it again reinforces voluntary licensing. So India being a country, especially in terms of pharmaceutical market, this particular compulsory licensing has been used time to time, for, let's say, anti-cancer drug or anti-HIV drugs. Those are like a kind of, it's more of a public policy related arguments. We cannot simply avoid or derail, that kind of requirement in the country. So there, when you reinforce a certain new ideas, we should go for voluntary licenses, compulsory licensing should be really controlled. And there should be some adequate remuneration as far as, licenses are concerned. So all these things again is creating ambiguity. So when for practical implications, when really someone with a technology company is trying to enter into, or even other vice versa, if things happening in the UK from Indian, some technology setup is coming to UK. So if these, fine nuances are not being adequately addressed, it will keep on creating ambiguity. And again, if you have to land up in the court or arbitration forum to get such kind of answer, it will take time. So idea should be, every country, national security, national interest is paramount. Whenever we are trying to make a decision as part of your country, this thing, we need to know what is the limit. It can go beyond a point. And to that extent, a lot of hand holding will be required. Maybe the moment it's getting effective, the impact will be seen on case to case basis, how things are happening. But to that extent, we need to really get clarity, and policymakers, lawyers, all other institutions would be like trying to develop this awareness. They should try to create clarity. So one of the things as in-house, as a corporate, as a commercial interest is paramount thing for us, right? So we'll go and invest when we have full clarity on things. And if we write a legislative piece, or we write something and it doesn't give you enough clarity to give the confidence to management, oh, you can do it. So that should be the idea when we deal with all these legal aspects of things. But having said that, as far as all IP laws are there in India, it's kind of doing pretty well. It's just like, that whole jurisdiction is adopted really very well. Certain segment like pharma and all remains exception because India is a large population. We cannot treat, similarly the way US treats or UK treats because we have a larger interest to protect. So that is something from IP point of view. I do feel that now it's a high time for even India to come up with, all clarity. They should not try to really bend on something which is not really feasible for the country as such. And again, to add further, on this particular aspect only, like geopolitics, typically economic sanctions and the way things are there around the world, it is impacting our day-to-day life, everywhere, be it China, be it India, in any other, like banking segment, all payment channels, every issue is getting really impacted. So when we do these bilateral treaty, country to country basis, and I know so many, dignitaries are here who can really think about it and provide better answer than me.
No, sorry. Sorry.
So bilateral treaty has certain limitations, in terms of many aspects of it. So when we do typically economic sanctions things or typically economic law, the way it operates, there also we need some more clarity how exactly things are going to, happen. So yeah,
Wonderful.
with that.
That's superb. Let me introduce everyone. This is Lord Chris Ravel. Thank you very much. I know he's been spent 8 hours in the chamber today sitting. So he'll know the debate today was on artificial intelligence. It was so popular that I think 7 hours, 8 hours, I'm not sure. But please, we've had just to give an update, we've had a really enlightening set of talks answering most of the questions. We haven't taken any questions from the audience panel, and we haven't talked about antitrust. That's one thing that the last thing on the agenda that we can speak about antitrust. But I'll hand over to you just to welcome everyone here, talk about the free trade agreement, and give a quick introduction. I think it's important for them to know how much you're behind.
Thank you, Rakesh, for stepping in. I was meant to do his job, but I think he'll do it better than I ever could. So, yeah. So I said I was meant to do his job, and I think he's doing better than I ever could. I'm so sorry I was late. As Rakesh said, you only know in the morning, and those of the peers here will tell you that when you're on the list, which order you're in, there's a debate. I was right at the bottom, and 45 people wanted to speak. And then you have to wait for the minister to respond, and then the person who brings the debate to respond. So my heart was with you. So I don't really know where the debate has gone, but I'll tell you one thing that I just loved. I think you might be interested to know. We're talking about the free trade agreement, right? So I was greatly privileged to be at the signing of the free trade agreement in Chequers. And would you be interested to know my one interaction with Modi ji? Would that be of interest? So he spoke to me. So my Prime Minister, Prime Minister Starmer, introduced me, and then he spoke in, Shud Gujarati. Where are you from? Which part of Gujarat are you from? And I said, Modiji, in Harrow, in London, North London, there is a street that is more Gujarati than Jamnagar, and I'm from that street. And he absolutely loved it. And I relay this to you because the free trade agreement is more than a paper. It's more, actually, it's just about to be ratified. It's more than that. It's about human interaction. And rightly, we talk about the history of our countries, but the future is really, really more exciting, actually. That as India becomes the third largest economy in the world, and London, not to say anything about the other cities of our country, but London becomes increasingly the financial hub of this world, the future of opportunities will be written in the language of law, certainty, predictability, robustness of boundaries, and you all are responsible for that. So I'll leave so I was a lawyer, so just I'm a failed lawyer. So I did my law at Cambridge and then never wanted to practice again. So imagine my surprise when Navin Jindal, right? So I was with him just 6-7 months ago, where they opened the world's biggest moot court at Jindal University. They had a French architect do it. It was just wonderful. And then they reenacted the Keshavananda Bharati case. Is that familiar to you? 13 Supreme Court judges on the dais, and then Mr. Singhvi, whose dad was ambassador here, High Commissioner here. So I knew when I was at Cambridge, I did my essay on organ transplantation, and far from the commercial stuff. But just indulge me because I'm getting into the pace. But are you interested in this little story? So I was just so interested that they did this, and they were referring, of course, to British precedents as they enacted this case. So we're enmeshed, and we're also enmeshed in the United States and goodness knows where else. So the future is very, very bright, and you should come to London, and you must come again and again. And that is my opening salve, and I can go on because I'm a politician, but I won't. I want to listen. Go ahead. Thanks, Raka.
Thanks very much. Do we have any questions from the audience at this point? And while you're thinking of a question, please.
Thank you very much. Michael Patrick Joyce. I'm a barrister, arbitrator, and mediator. And I would like to go back to a phrase in the session title about enabling the new wave. And I'm so pleased that you spoke about moot courts, because the new wave of anything is in education and youth. And that underpins the rule of law, it underpins facilitating investment, facilitating commerce, etc. For many years, I've been involved in the FIS, and I've therefore seen teams from around the world, including teams from India. And I can say that the future is bright because I have seen the excellence of students from India. And in terms of making the most from the new UK-India free trade agreement, then investment in education on both sides of the free trade agreement, and indeed around the world, is, to my mind, the central ingredient to its success. I'm sorry, I didn't ask a question. Does the panel agree?
Thank you. Please. State your name and where you're from.
Hi, I'm Mayuri. I'm a disputes lawyer, arbitration practitioner based in Mumbai. I've had the privilege of working with Sudhanshu on a few of my matters, and I completely agree with what Mr. Hemawat had mentioned. I've also had the privilege of doing a BIT arbitration, which was routed through India, UK, old BIT. Although it was unconnected to India, I was related to Macedonia. But the question, it's first a comment and then a question. One is there are a few things which were spoken about in India on this particular panel, and I just wanted to clarify a couple of things from where things have moved. And Babita, to your point, I think there has been a lot of movement, at least from the Ministry of Finance, on having specific teams dedicated to treaty negotiation and specific teams that are actually working with stakeholders such as NIRA, such as other investors in India to understand where perhaps rule of law may be impacted, where governance issues are arising, because often actions of the state government lead to the level of investment treaty. And that's where we've been hit the most, which caused India to pull the plug, as Sudhanshu had spoken. So there has been a moment, and the Indian government is investing in really good young associates, people with experience, etc., to join those teams to sort of make it more robust and follow a little bit of the US style of treaty negotiation. So that was just one comment. And my questions, because this is on free trade, we are discussing free trade, and I'm congratulations on doing that. Thank you, because most of our clients, etc., were wondering what is going to be the protection that Indian investors are having when they invest outside India, because when the plug was pulled, the investments in India were sort of protected for 15 years. But the Indians, a lot of Indian companies and conglomerates did not have that protection. So the FTA is a really big development. My question was perhaps to anybody, but Babita, maybe you could answer, is, as a stakeholder who's investing in India, what would you like to change? What were the few changes that you would like to see in India to sort of protect your investment better, for ease of business, etc., which can be things that we at Arbitration Bar of India could help in sort of training our judges, or training our other stakeholders within India. Are there some feedback that you could have as general counsels, etc., of companies that have invested in India?
Thanks.
Thank you.
Thank you.
Can I
Please,
share a
Babita.
few thoughts?
Yeah.
I'll give a really practical example of something that I did in India, which was reflected to me the difference in how someone outside of India might perceive something. So I was on a TV, news show, right? And there are 6 people talking at the same time, literally, right? Yeah. And that is common, by the way. I will often, if I'm in India, turn on the TV and there'll be 6 people or 3 people at least talking at the same time, and they're all presenting their view, and I can't understand because I'm hearing 3 different conversations. That is common in a lot of scenarios in India. There is a lot of conversation. And I think what I would like to see, and honestly, I don't think actually in India people realize that this is a source of huge confusion for international investors. But I would like to see perhaps building of awareness of challenges like that, and then perhaps a convergence in a sense, or an approach which is investor friendly, recognizing that someone from outside might not be used to that, and seeing if we can sort of consolidate that thinking into something that is investor friendly. That's just a very basic example, but it's something that can be applied. So when I was talking about the volume of information that is shared about cases and outcomes, there's a huge volume of that. And the reflection that investors often have is that there's so much going on. There's so many different perspectives, cases that have been decided this way. There's some things that have been decided this way. I don't understand what my outcome is going to be. And if there is, again, some understanding of, that, I mean, it's commonplace in India, but people don't understand that.
Thank you. Please, Lord Chris.
Just make a comment on your comment, because I thought what you said was a really important point. So when in 2017, India terminated not just the UK-India BIT, but its other BITs, the premise was that India is a capital importing country that is always just going to be on the receiving end of these BIT claims. But the really important point you make is India was and is increasingly a capital exporting country, with Indian investors going outwards to invest all over the world, not just in Europe, Africa, and South America, who need the protection of these BITs. I don't know what the answer is to your question, but it's a really important point. It's not just a one-way street. Yeah.
So, could I just come back briefly to Michael Pettit-Joyce's question a moment ago about the education and the importance of the moot courts? Yes, the moot court is a wonderful way of teaching somebody how to present an argument, how to think on your feet, how to connect to the person you're talking to, and generally developing your thoughts in a very clear and convincing way. Lord Krish and I have spent most of today in a debate about AI. And AI puts a lot of those things at risk because the temptation to go straight to whatever it is and just to take all the stuff and not to think it through and to present it and not to check it and perhaps to even present some hallucinations or whatever it is that has cropped up. That is a real challenge. And in this context, I think we all have to be aware how to manage AI and how to keep these precious oral traditions and ways of thinking and ways of expression and ways of thought that are critical to our civilization and our cultures.
Thank you. There's one word that always comes up in many of my discussions with India, with a lot of people, Thomas, and that's the word antitrust. So if anyone on the panel has an opinion on the direction of change, just in that phrase, and the relationship to this discussion, is there anyone on the panel that could say a few words on that?
Well,
my question was in terms of what kind of changes we would like to see as especially general counsel. So I'm Seema. So
sorry, mic's on.
It's on. So okay, my voice quality sort of.
You're behind.
Yeah. Okay. So let's say Delhi High Court. It's very efficient. Court. Very exemplary. Brilliant judges sitting. And one thing which I feel all the time, and I'm in a sector which is highly litigious. I would be having more than 200 litigations. Which I'm handling right now around the world. So something called time bound, when we have some high pressing matters, we do get, judgments also sometimes very, maybe in a day or two. So it's a lot of successes also we celebrate, but we can something classify, what should really get priority and there, we should be having some dedicated judges who can really hear the matter on priority and then provide some instructions or guidance, some status quo they can maintain. So it's just all like given to all sort of discretion, It's just like quite messy sometimes. You exactly don't know what are the few steps you need to take, although we are practicing for so many years. So that part is still somewhere someone needs to crack, how exactly to pursue and what should be those, line of jurisdiction. Maybe top 3-4 courts of the country should be declared as, like they can handle high priority matters, Like in the past, let's say marine, this all maritime jurisdiction, shipping. So 3 courts, high courts in India had jurisdiction, Chennai, Delhi, and Mumbai. Earlier it was only Mumbai. Now it is having with 3 jurisdictions because Mumbai high court was overloaded. So that was something, it's like a very out of the blue and very kind of out of the box kind of, decision making where we try to, really classify things and make it more broader. And then we do get a lot of avenues to get remedies. That is the big thing.
Thank you.
Consult India and tell us how to change that.
Did you want to?
Well, if we just make a quick comment on antitrust or competition law, which I think is what you wanted to do. If I go back 15 years to a time when I was at Linklaters, we were doing an international transaction. I would find myself chairing a call with Washington on the call, with London on the call, with Delhi on the call, with Beijing on the call, and everybody was, as it were, talking a common language and was working out how to get this transaction through the various jurisdictions on a basic common understanding that international trade was good, that international border cross flows were positive, that it was very important for businesses to collaborate internationally, and so forth and so on. I suspect in the last 5 years at least, that scenario is much less common, and that we have been, as was earlier said, falling back into a world of reshoring, of concerns about national sovereignty, of control, as you were saying, over inward investment, which is another kind of protectionism, effectively. So I do worry about antitrust and competition in the international sphere. It's still important in the domestic sphere, but even domestically, here in the UK, we've seen competition authorities on the back foot and not, for example, standing up to where the real monopolists are, which are the big tech companies and their associates. So it's not a particularly positive scene at the moment. I don't know if you agree, Lord.
Yeah, I do, Lord Bellamy. I very much do, Lord Bellamy. And just this, in the free trade agreement, unlike the ones that we have with other countries, there isn't an actual chapter on antitrust. There is something on competition, but there deliberately, and my understanding is that it was something that the Indian side insisted on, that there isn't a chapter on, there isn't provision on antitrust. There's some guidance on arbitration and this sort of thing, but nothing specific. It was very deliberate because we didn't make an issue of it. But I wonder why.
So I'm often involved in transactions, what we are increasingly finding, especially now with the UK, I mean, we're just consulting on the competition regime consultation that came out at the start of this year, where they're going to make changes potentially to the panel structure that we currently have from a merger control perspective. And there's a concern of whether the regime is becoming perhaps more political. There's more that these independent institutions may become more subject to industrial political policies, and how that feeds into decisions. I mean, increasingly, if you look at the number of cases that the Competition Markets Authority has looked at last year, there was over 800 cases, and only a fraction of them, 37 less, were called in for phase 1 review. So there seems to be definitely an appetite now for the authority to, get transactions through. But again, there's concerns about really, does it have the same teeth as it once had, 5 to 10 years ago? But as you say, I'm increasingly finding it's not the competition concerns any longer that are slowing down transactions. It's the foreign investment aspects now. So my colleagues will have completed the merger review and all the filings are cleared, and but I'm still months away from getting the FDIs. So it's the hot issue now amongst authorities, and it's the one that's slowing down these investments and creating more unpredictability for investors, and the more guidance that can be provided by government as to what are the concerns, what are the red flags, that would be powerful.
Thank you. We have run out of time for questions, unfortunately, but they will be here during the break to get questions. I just wanted to say thank you very much, first of all, to you, the audience, to BCLP for hosting the session, and a really big thank you and round of applause for our participants today that have really shown in excel. Thank you. We'll change panels now. Thank you.
I do exist. Yes. Well, it's, I mean, ever since they sat down, the credibility. But they did.
So you are yes.
It must be. It must be the end Sorry, I have to.
Take a picture.
Yeah, we go there. I'll take a picture. Can we grab everyone for a quick photograph? 15 photographs. Just here.
Still chambers are the best. I just say.
Where should we do this?
We're going to have a photo. Yes.
Yeah, please come around. Come around.
to come in.
Thanks for having us.
Okay. Which camera first? Go back. No one over there? Okay.
Nice to see what you said. I got into trouble with Black Rock because
Yeah, mine too.
Better to delay that. Big legal smiles.
make me look young.
You are standing with me.
That's why I'm saying.
Okay, so nice of you. Thank you.
Thank you.
I'm trying to pop if I can. I just joined.
And my question actually
Because of this.
So we're actually hosting a reception by
The other guys, the opposing
in terms of, so I also head up the structure around what's needed. So I
That was an eye-opener.
So you all want the right agenda.
I totally agree with you. I use this
That's everybody. I'm taking yeah, there are things which I had never thought of. Oh, God,
Great. So that I would actually say
Advisory has been allowed now.
yeah, I got to certainly
you should try.
Yes, I did. We did. Very business.
I would have to introduce myself.
Where's the dancer?
Oh, okay. So you're in Mumbai, right?
Maybe find something. One step at a
Ryan Tish. You know Ryan? Please, weekly we are on a video with him. And Ryan and
One, two.
I think we met when you lost exactly. That's Paul.
exactly. So this is what I'm saying.
We keep meeting Atul, but we never met you so far. Even in my wildest imagination, I would try to connect us. At least
Okay, this one's full failure. So still very good time.
yeah,
Yeah, like
So you are
Idiot, but I had to go back to the office. Yeah, I know. Sorry. When you headed back?
I had let's catch up to see my so one is in
LIDW and we meet for the first time.
I know. It's like an Indian wedding and you see everyone. Some people are very red-eyed, bleary-eyed, you know what they've been up to the night. Somebody else gave you a picture for my heart, and that would have planted the back. I am a 948. Yeah.
My name is Siddharth. Well, right, you can
See, with 13 years been going, that's not possible. Yeah, this is a great organization. And whenever you went to India,
Christine is
No. They said periods of the year they do it. Yeah. I've joined here in things. I'm not super good yet. Yeah, that's the
no, I did it to on this so that I can share the discussion. So I'm also here. I spent a couple of months in I joined BL. How 6 months and so we had
I do this all the time. Yeah, I'm just like.
Yeah, sure. Have a great weekend.
I love that vibe. That sounds great. And it sounds like what he's talking about And say, it sounds like exactly, it sounds like, and basically it's like your description, you can put it into your practice. So that's very interesting.
GCAI happens to be my hand to be
You might well correct me. I'm not going to speak here. Yeah. My assessment. And also, again, side of my practice. So in India, I would argue more focused on more secular. Social finance.
Let's chat on email.
ILS Pune. Yes, Mumbai is Pune. Queen Mary. She worked with me in Vedanta time. She used to look after our power business. And Kanita.
Any need to done.
Be here,
My sister, very close
Hello, hello, hello. May I request please everyone? May I request please everyone to be inside? Akhil. We're getting going?
Please make your way through now to the conference.
Right, thank you.
My background is from multiple.
I'll just go to the restroom and.
Okay, perfect.
Very
perfect.
Hello. Hello.
Close the door so you can start.
Good afternoon. I think we need to start with our session 2 now. And I must take this opportunity to thank everyone for being here on a Friday afternoon, which I know is not a very popular afternoon to come into work. So thank you for that. Our current session is on dispute resolution 2.0. We've got with us a stellar panel who really need no introduction. Now, as commerce becomes more global and technology-driven, dispute resolution must evolve with it. This session will examine the future of arbitration and mediation through the lens of London and India, exploring not only the respective jurisdictions, but also what these jurisdictions can learn from each other as they adapt to technological change, AI, and evolving expectations of international users, given the deepening UK-India cross-border trade. Now, without further ado, I would like to introduce our esteemed panel. We've got, starting from that side, we've got Karishma Vora, who's a barrister at 39 Essex. Next to her, we have Sapan Gupta, who's a Group General Counsel of ArcelorMittal. Right after, we have Mahesh Agarwal, a very prominent advocate on record, and as I was told, the busiest in India. We've got second confirmation of that from the audience. Then we have Gaurav Banerjee. I think we could spend a long time introducing him. He is the president of the Arbitration Bar of India. He's a senior advocate in India, and he's also with Essex Chambers. Next to me is Sharina Petit, who is head of arbitration, head of India practice at Stewart's, and she has kindly offered to moderate with me. So we will be your co-moderators for this panel. And we've got a few themes that we want to ask of this panel. We are trying to step away from the usual discussions about London and India and how they compare with each other. So this session will be a little bit controversial, but hopefully not too much. Starting with theme 1, which is what UK and India can learn from each other. Now, there is a long-standing legal history between the two countries. A lot of cross-border disputes, a lot of cross-border investment. The two legal systems have a common law heritage. But on paper, while they may be similar, in reality and in practice, they couldn't be more different. Yes. What that leads us to is there are surely lessons that both legal systems can learn from each other. Sapan, if I can start with you, please. You work across both systems, India, and now you're based in London, with operations of ArcelorMittal worldwide. What would you say is the single most valuable lesson the UK and India can learn from each other?
Thank you, Shivani. Thank you for hosting this panel. Thank you for GCAI to come here and try and the General Counsel. So just press that. Yeah. So thank you to GCAI as well. I think it's hard to say that what's the single most learning or cross learning. There are a few things which can be learned by India from London is of course LCIA center. London is a global legal market, so you have a plethora of experts. And I was just exchanging notes with Karishma, and she made a very, very valid point where I agree with her, is that in London, the briefings and the examination, cross-examination, everything is very well timed. It doesn't go on forever. And the filings are limited, that you cannot keep on filing application after application and documents. So I think that's one thing which India can definitely learn. It would also help with reducing the backlog which Indian courts are facing. And as far as India has to give something back to London, I think is when we work with the solicitors here or registrars here, they are used to getting prepared in a particular way. And some of them don't even have the advantage of law firms always, like in India, every time you have a law firm, every file. They go very prepared into the matter, but if the matter moves a little bit or arbitrator or judge asks something, their ability to think on feet, I think, is not as sharp as the Indian lawyers, because Indian lawyers are dealing with so many matters in a day that they are able to maneuver the court, if that's the right word. Where the solicitors, as they are very well prepared, they don't take their own time. It's very, very hard to convince the English bar once they have made up their mind. From the general perspective, it takes a lot of effort. So maybe these are the things I would say in general.
Thank you, Sapan. I think that is a very, very valid point, and many in the room would agree to that. Mahesh, if I could please come to you now. Sapan mentioned about how multiple filings and there being this lack of discipline in the litigious culture that all of us Indians do have. Talking about a learning that can be probably taken from the English system. Now, the English courts use costs as a tool to discipline the behavior in litigation. So for example, you have security for costs, which is when a claimant files a claim, that claim cannot proceed until they have put up money for what the other defendant, what the other side would have to pay in terms of their legal costs, should the claimant's case fail at the end. And of course, at the end, if the claimant does fail, they have to pay the costs, the legal costs of the winning party. So the loser pays rule, which is very integral to the English system. Do you think Indian courts, given the volume of cases that are pending before them, do you think Indian courts could use adverse costs as a tool to reduce the number of litigation before them, especially frivolous litigation?
I think that's a must. What has happened is in India, traditionally, you go back 30, 40 years, the litigation cost was not much. You go to a district court, you go to a high court, you don't have to pay for the legal system. You have to pay for a few lawyers and a few hearings. And therefore, the concept of actual cost was never there in India. Now, there have been some legislative changes, but that has not been enforced even now. Most of the time, even after a contentious matter, which has gone on for days together, last order is no order as to costs. Basically, nobody has to pay anybody. So what happens then is that obviously you take a chance. Even if you don't have a claim, you want to delay enforcement, you want to delay recovery, you file some frivolous case, go and appeal after that, and then review and then curative, because no cost to you. There's no stake in the game. Now with this costs increasing in India also, Counsels sitting next to me, the kind of fees they're charging now. So it is pinching. It is pinching parties. So one way to reduce frivolous litigation is definitely impose actual costs. There has to be a proper assessment. There has to be a proper security of cost mechanism, but it is still very nascent in India. Neither the judges nor arbitrators are really attuned. But it is now sinking in that after seeing so many cases where matters are dragged and frivolous cases are filed, to curtail frivolous litigation, now both the parties and also the judges are enforcing actual costs. So far as security of cost is concerned, that's a concept which has started from UK, now coming into India. India, there was no such concept of security of cost. But now we have realized that after end of litigation, supposing costs are imposed on you, I mean, you can recover cost from the other side has gone bankrupt. There is no way you can recover. So now security of cost system is coming in. That will also curtail frivolous litigation.
Thank you, Mahesh. Arishma, can I come to you on the same topic? What do you practice in both India and the UK? What do you think can be done to reduce the pendency of cases before the Indian courts? And before I come to you, I just want to give statistics out to the room, which I love giving out. If you look at the Indian Supreme, well, let's start with the UK Supreme Court. You've got about 50 to 80 cases in 1 year. You go to the Indian Supreme Court, you've got 80 cases in 1 day in one courtroom. So the legal systems, the reality, the difference really starts from there. So Karishma, what do you think can be done to reduce the pending number of cases before the Indian courts?
I think I'd have to take a leaf out of Mahesh's textbook. Costs is, of course, and imposing costs is a excellent way to reduce litigation or reduce the number of cases in court. India does have the system in theory, but it's just not enforced in practice. And certainly, I think when Indian senior counsel fees are put before Indian courts, perhaps taking a leaf out of the English law on costs, which is that they must be reasonable and they must be proportionate to the sums in dispute, is something that can easily be applied. So long as the counsel or the legal team's fees are reasonable, there's no reason why an Indian court cannot say that the losing party must pay the winning party's costs. It's also already adopted in Indian arbitration. So that is a step forward. We've come a long way from, I think, one of the first cases that I did at the Bombay High Court, where I was thrilled to get a 5,000 rupee costs order against a government PSU. So things have moved on. And costs is also a manner in which the pendency of cases in England considerably reduced. It actually worked. The second is mediation, and my good friend Nitesh made this point earlier today about how mediation can reduce at least commercial disputes. And commercial parties litigating against each other in India are really the ones that face the brunt. Those that are litigating against governments, etc., there still is it's delayed, but there's scope for it to go all the way up in terms of appeal and be resolved. But commercial trials are few and far between. One good way to resolve them would be mediation. And if one were to look at other jurisdictions where this has worked, Australia, for example, considerably reduced their pendency by adopting mediation in all sorts of matters, not just commercial matters. They also adopted it in family, employment, so on and so forth. And the third is to allow perhaps senior practitioners or senior counsels to take up part-time appointments as judges. This has been controversial. It would be very good. We don't have a judge on the panel today, but an Indian judge on the panel today. But it would be good to hear from Indian judges if they were comfortable with having senior counsels and making it compulsory for senior counsels to sit part-time to help reduce the backlog.
Thank you, Karishma. That's a great point about how we have deputy high court judges who are practicing barristers and advocates. Well, you'll have to see what the Indian judges have to say about that. Gaurav, please, can I come to you now? And we heard about the growing costs of lawyers in India, and I believe a finger was pointed at you. I think many in the room could have the same finger pointed at them. India at the moment doesn't allow lawyers to partake in success fees. It's considered shambhatus. Now, England obviously started with that position, but now lawyers regularly engage in success fees and partake in the outcome of a dispute, whether it's as damages-based agreements where lawyers don't charge anything as the case goes along and only get a percentage of the award, or they do a conditional fee agreement where they charge a percentage of their hourly rates and they get an uplift on success. Do you think India needs to adopt that so that Indian lawyers can partake in the success?
Can I respond to that after I respond to them?
Sure.
So, on costs, I think you have to understand the mentality of our judges and the background from which they've come. And I think there's a difference in vision on this. I think England has adopted a principle of having high costs, which effectively shut out a lot of litigation. That's a policy choice. I think the Indian policy choice was different, is different. We've had this discussion with many judges, but for a very few, they would like to keep the costs low, court costs low, and they would think it is a matter of access to justice. So that's one part of the story. And that is perhaps why, even though there's as Mahesh pointed out, there's a legislative change. In commercial matters, you are supposed to give actual costs. In practice, very few judges actually do this. I can only think of two retired Supreme Court judges who would give actual real costs. So that is one aspect of the matter. But certainly in commercial matters, I think they should give actual costs. We are now seeing in the last 2 or 3 years arbitral awards where judges or arbitrators are actually giving you a very substantial costs award. Unfortunately, when they give you this large costs award, when it is challenged before the High Court, the first thing that falls is the cost award, because the mentality still is that you do not, how have you given costs of 1 crore rupees? You may have paid fancy senior counsel, but you will not recover your whatever. So that is one, I think it's a mindset issue. I don't know what the answer to it is, but I think it is the nature of the judge or the arbitrator, even in commercial matters. They find it very difficult to award large sums of money when in their mind, 95% of the cases, the numbers are much smaller. So maybe that is the reason that they don't do it. So I think it is certainly a learning from here, but I would nuance it by saying that we are not in a situation to adopt, even in commercial matters, that strict sort of high bar because that's not the mentality of the judiciary at the moment. So that is.
Yeah, but just to react to that, that if you look at the access to justice point, and if you look at the constitution, the whole amendment to the Indian Police Act, the purpose was that when India got independent, the literacy was very low. People did not have access to justice, and they said, okay, we have to make it comfortable for people to go to courts, and we should have higher number of lawyers, higher number of courts. But that's now 75 years out. So is there a time, and then now we are commercial matters, we are talking billions of dollars, pure Indian disputes, fees being one part of it. So hasn't the stake increased so much that the mentality has to change, because now we are not.
I think you're right. The mentality has to change, but the reality is the mentality. I don't know how that we're going to achieve it. How do you convince a Supreme Court judge or even a High Court judge to actually, compensate you for having won the matter and give you back your costs? I think there's a real issue. I think
another reason could be that majority of the litigation in India still is with the government. So whether it's the tax department, property department, most of the litigation, if you see in Supreme Court, 70% is against the government of India. Now, if the government of India is a party or the state governments are a party, then the courts are very reluctant in imposing cost on the government, whether they're right or wrong. Because if they do impose cost, and the government officers would then kind of not take a position which they should take, the policy matter. So that is also a kind of reason because of which actual costs are not there. Insofar as arbitration is concerned, I know for a fact, in some cases, the arbitrators do not want the High Court judges to know their own fees, because that will be part of the cost. That is not granted. I know for a fact that's happened in many cases, that the arbitrators have charged 1 crore of rupees, and if costs are awarded, that entire fees will be before the High Court and become subject matter of controversy there.
That's very interesting. I mean, look, and I think the point is that judges do find the growing cost of litigation to be very high. Even in England, I've been at firms where we've been criticized for putting in what are called eye-watering numbers we recovered from the other side. And as a general rule, at least in litigation, in arbitration you can get more, but in litigation, the thumb rule is you get only 66% of your costs, and you have these guideline band rates where for band 1 of a certain law firms by postcode, and then you have, and you have firms in London who are allowed a certain rate, firms outside London allowed a certain lesser rate. But
also we don't have a provision of taxation for costs. You don't have a separate mechanism by which. So when the judge writes his judgment, the costs come in 3 lines at the end. So you don't have, application of mind or a separate procedure for taxation costs. Somebody looks at it and says, this is what you're going to get, and maybe then the judge. We don't have it. It's there in the statute book, but it just doesn't happen.
We will not need different bands in Delhi. All of them live in the same place.
Touché.
Just to pick up on Gaurav's point, so quite right. Then there's most likely going to need to be an amendment to the CPC to introduce a section on costs in order for it to be sort of taken seriously, because once it is part of the CPC, arguments can be made on costs, and a whole body of jurisprudence will need to be developed, but very carefully also bearing in mind access to justice. So which cases, will it only be commercial cases with 2 private parties or otherwise? But
there are some provisions which say, there are provisions in CPC which say, you've got to now give actual cost. So it's there, but nobody really ever puts it there in front. Sorry, I didn't answer your question, right? Success fee.
Yes.
I think okay, fine, fair enough. I think the reality is, great question, but the fact is, it's already there. However much we might think that it's not there, it is already there in some fashion. And I think what is relevant is that it's tied in with third-party funding, and we need to regulate it. You can't run away from the fact that it exists as a matter of fact. And there is third-party funding, and there are people there who are entering into agreements with contingency fees, not for lawyers, but for the funders. So there's that thin line that if you're a lawyer, you can't have success fees, but the funder who's not a lawyer can have it. So it's already there. The architecture is there. The people are there. It's just that the Bar Council of India has to turn around and say, well, this is the reality, we should regulate it, instead of saying law is a noble profession and, we are just wonderful people. It's all professional. It's not a business. So once you get away from that and you regulate the reality, don't advertise. Is it advertising? I don't know. Maybe I'll get in trouble.
As long as it's not on a website, I think it's okay.
Okay. No website.
Yeah, your point is very pertinent. I mean, I remember when I started my first as a trainee solicitor in London, about 17 years ago. The first thing we were told is law is a business. So, and that's in very deep contrast with what how in India the legal profession is viewed. Over to you, Sharina.
Time. Sorry.
No, go ahead.
No, I personally feel I don't agree with Gaurav. I think we still in India is quite a noble profession. Already the legal profession is marred by so many controversies. There's a lot of allegations made. And now when you have lawyers getting interested in the result of the case, it is like a mystery person. So I think that should be completely avoided. Lawyers should not be getting any success fees. They can charge whatever they want to, but they should not be part of the litigation.
Yeah.
Litigation funding is quite a separate thing, which is there, which should be recognized. But a lawyer or a law firm themselves getting involved or getting a stake in the litigation, I think we are not that much matured as of now. The Indian system is not that mature.
Thank you.
Moving on to theme 2, which is enforcement. Obviously, it's all very great to have an arbitral award or a judgment in your hand. But what's the greatest bit? And that's half the battle. But the other half the battle is actually having money in your hand. And so actually I have 2 questions. I have a question for both Tapan from a user's perspective, given that you're the GC of a company, and Gaurav, who straddles between the UK and India, on the enforcement. So seat is important, obviously, when you're drafting your contract, and that will be your nationality of your award. But what's really important is obviously enforcing that award in a jurisdiction. The question is really, how do you, from a user's perspective, as a client, you then, Gaurav, you can get ready to see whether you would disagree or not with what's up and saying, but what do you see between the UK and India enforcement?
I think in our view, enforcement is probably the biggest issue for the future of arbitration globally. All jurisdictions have their peculiar problems, but the enforcement is a real issue for the arbitration. And India is worse than UK, but I wouldn't really say even UK is great at enforcement. And by the time you reach enforcement, the assets, one is the state entity and the other is a private commercial party. Private commercial party, you will see the assets have been round tripped or have moved to other jurisdictions. And typically it will move to jurisdictions where either there is no proper court system, the court system is very, very slow. For the disclosure required by the court or forced disclosure is not enforced. We may have entities which will be in India and in UK. Enforcement has been a real concern. And we have started doing more work on diligence at the time of the contract and putting on and ring fencing at that point of time. That how do you control, how do you move the assets, how do you stop round tripping? And at the time of enforcement, there are asset tracers, there are many other agencies. But unfortunately, it has not moved at the pace where it has. Where it is currently, UK courts are slightly better in giving impugning orders or freezing orders compared to the Indian courts. But India still doesn't have a lot of foreign assets. So unless you are against an Indian party, which has assets in India, India still is not a center for non-Indian parties to park their assets. Whereas London is and UK is. So you are likely to find assets in UK for a global party than in India. So UK is much more important, slightly better than India, but I think it's an issue worldwide.
Thanks. Do you have any war stories of enforcement?
Pallavi said she will quote me, so I'm not giving.
And neither will Bhumika. I'm giving you that commitment.
Yes. Sorry, okay, you want a reaction to this? I think actually, you know, we start off with a very high threshold. How many judgments are enforced worldwide? You have a situation where you have a foreign award, you have this New York Convention, which is a wonderful document. You can actually take an award and go wherever you want. So the expectation is that enforcement is easy. So let's talk about enforcement of a foreign award in India. So you have there are problems in other jurisdictions. For instance, Dubai, there seems to be a problem because we've not notified it. But leave that aside. We are only talking about England, English, notified country. English award being enforced in India. I actually believe that there are two categories of matters in the courts now. One is what I call legacy matters. So legacy matter is like a HSBC Avitel matter, which went into cold storage 10 years ago, which has now been dragged out, and the Supreme Court says enforce it. The matters which have come to court in the last 3 or 4 years, the speed of enforcement, I don't know what Mahesh says, Mahesh may have statistics, but the speed of enforcement is considerably faster. You get, even in, I'm not talking about Delhi, Bombay, even in other courts where you want to enforce a foreign award, because of myriad conferences like these, the judges are tuned to, you know, look at a foreign award, look at the defenses under 5A of the New York Convention, and by and large, they are pretty pro enforcement. And the numbers are very small. You would think Delhi High Court, how many petitions are filed for enforcement in Delhi High Court? Premier High Court in a year, foreign award.
Should we throw this open to the audience?
How many?
How many do you think?
9. 9.
Really?
Yes, really. So you can see it from the computer, arbitration petition, OMP, whatever, 1 of 2026, 2 of 20. So 9, 10. Bombay will have the same. So there are very few awards which are actually foreign awards which are getting enforced. Because people, as Sapan said, it's only an Indian party who's lost abroad with your assets in India. So there aren't that many. And because of optically, you know, all this criticism, I think enforcement of foreign awards, we're not talking about Indian award, foreign awards is fast tracked. So I actually think we are in a very good position there to get relief.
Well, thank you. Thank you, Gaurav, for that. Anything from Karishma and Mahesh on that, or on enforcement, or we can move on? Mahesh? Nothing. Okay. Sorry.
What about in terms of foreign judgments?
Foreign judgments, very few and not a good track record. Difficult Section 13, Section 44 notified, the fast track. I think mine will be a better position.
No, I think what is actually happening is, so far as foreign awards are concerned, that when you file an enforcement in India, the enforcement is super slow. It can take many years. I agree with Gaurav, the number of cases are less, so it is faster that way. But still, the courts would like to go into an enforcement like it's a challenge. Many issues are there. So I think practically what is happening is that after a foreign award, the parties do get into settle. Many cases are actually getting settled and resolved rather than for enforcement. Because enforcement, if you go for enforcement, you know it will single judge, division bench, Supreme Court, 10 years are gone.
Actually, you've hit the nail on the head, Mahesh, because I've had so many of those situations where settlement has happened after.
Exactly. So that is what is happening. If somebody comes to me, with an award, I would say settle at 40%, 50%, even if you have succeeded, rather than waiting for enforcement in an Indian. That's practically that's what is happening. But anyway, the end result is that it is getting resolved.
So, Mahesh, since you have the floor, it's a question on anti-suit injunctions, actually, and whether clearly Gaurav doesn't like that question, but anyway, Mahesh, are courts striking, do you think, the right balance in protecting arbitration agreements? Or are there tools like anti-suit injunctions, which we constantly see happening, being overused tactically?
No, I think courts are now tending to respect the contractual rights between the parties. A and B have entered into contract to go for arbitration. Now, obviously, an Indian company or Indian party who's facing an arbitration award, arbitration outside overseas, would take a chance at anti-suit injunction. Correct? But parties, the courts are tending to respect the agreement between the parties. The number of anti-suit injunctions getting granted are very, very low. There are few legitimate cases where injunctions have been granted, where you can actually say it's vexatious, or it is in a jurisdiction which is outside the contract, or it is contrary to the agreed law between the parties. There are few cases. So the scope of granting anti-suit injunction is very low, and the interference by Indian courts is also lowering now. And they are respecting international arbitration and they're respecting agreements.
Thank you. Karishma, it would be great to hear from you about the UK perspective.
I think there are two aspects to this. The, of course, equally, I agree with Mahesh. The English courts also echo and have a very high threshold, which is the same. It's oppressive and vexatious that needs to be proved before one can get an anti-suit injunction in London. But I think between the India-UK corridor, there are two types of anti-suit injunctions. One which are going into High Court and above, and the second which are going into the lower courts. I think the High Court and above is exactly as Mahesh has been saying. The leading case, of course, over there is Malhotra and Malhotra, where Justice Patel of the Bombay High Court mirrored and echoed and respected the judgment of Justice Walker in England, where they said to shareholders at war or warring shareholders should go to arbitration, and did grant an anti-suit injunction because they said that it would be dressing it up as a claim between a director and shareholder of an Indian company. So they said, no, this is not oppression and mismanagement in India. It must go to arbitration. And it's great because it shows the comity between the two countries and how courts respected each other. Then I come to a completely different scenario where I have seen cases in England where a district court in South India granted an anti-suit injunction against the English High Court proceedings. I think, correct me if I'm wrong, the district court doesn't even have the jurisdiction to do that. Instead of going in appeal to the Vijayawada High Court, they filed a completely new writ petition in the Vijayawada High Court, which meant that once again the party, if you want to call it the victim, was not alive to the fact that the proceedings even existed. And simultaneously, on the day that they went to the Vijayawada High Court, they filed an anti-suit injunction in London, which means it was a complete block because there was an anti-suit injunction in India as well as in the UK. And this is a situation which is completely tactical. And by the time the judiciary has an opportunity to apply its mind to it, a lot of damage has already been done. But this is rare. And in terms of numbers, I wouldn't say it's very high.
We'll now move on to our next theme, which I'm very interested to hear about from our speakers, which is the liberalization of the Indian legal market. We've had rules from the Bar Council of India in 2023 and 2025 last year, which have in effect liberalized the Indian legal market. Obviously, what has not followed is international law firms setting offices in India. I think our panel here is very well placed to answer questions about this. Mahesh, I'm going to come to you. Do you think the new BCI rules mark a genuine inflection point in the internationalization of India's legal market? And what is the practical implications of the recent set of rules in 2025?
Just telling him he's going to
I'm
be
a bit of a conflict here because I was part of the committee, the Bar Council for the rules.
So what was the committee's recommendation?
Not that great. So the problem in India is that while generally we would want foreign lawyers to be able to practice in India for international law or for foreign clients, there has to be a legislative change. As of now, the legislation is virtually barring foreign lawyers from practicing in India. The restriction is that a foreign lawyer cannot operate in India, advise on Indian law. He cannot operate in India and advise Indian clients. So there are major restrictions. All you can do is come for non-litigation work, kind of for mergers, acquisitions, advisory, etc. But that also for foreign law. So Indian market, though the rules say, is not really opened up. Until and unless there is a proper amendment by the legislature, it is going to be a difficult. You can't say too much on this.
No, thank you for that still. Gaurav, coming to you. What these reforms, especially the 2025 rules and the clarifications that came out, do you think, in your opinion, these reforms will meaningfully strengthen India's position as a global arbitration hub?
So this is the first time actually, I think Mahesh has explained the rules in general. So from my point of view, I only look at the narrow arbitration exception. Previous to the rules, there was some consensus that international commercial arbitration was treated differently. Now, previous to the 2025 rules, the general understanding was that even though it was seated in India, and even perhaps if it was, international arbitration with Indian law, you could have foreign lawyers. But the 2025 rules, I don't know, I said this somewhere else, it's clear as mud. You don't know what it is. And what has made it worse is the number of clarifications. And those clarifications have come in very unusual circumstances, in the sense that they seem to be connected to some particular events and instances. That seems to be I can't say any more about it because I definitely have some idea about that. But the result of this is you have rules which are unclear, you have clarifications which are unclear, and there should be a carve out. I understand what Mahesh says is legally that you need maybe an amendment, but there has to be some sort of carve out for international arbitration. I have no expertise on the other areas. I think Mahesh will be much better placed to give you a broader picture. But certainly for international arbitration, there should be a carve out. Otherwise, all this talk of global arbitration hub is, personally, it's great for me. I've been instructed in 3 new matters because all these lawyers couldn't turn up. Wonderful. India seated arbitration, Indian law, great for me. So, great rules for me.
So the reasoning appears to be that if it's a India-seated arbitration, then the law is the Indian law which is applicable. And the concept is that a foreign lawyer cannot advise on Indian law. It is difficult to say that a lawyer who cannot advise can argue on Indian law, explain Indian law in arguments, or be an arbitrator to decide on Indian law. So that there is a disconnect which has to be sorted out.
Arbitrator, no problem. The section says you can be a foreign arbitrator. I agree. An arbitrator, you need not know any law.
Correct. You can be
no problem.
I'm probably going to put my foot in my mouth by asking this question, and it's not a planned question. Mahesh, you talked about a foreign lawyer advising Indian law in an Indian-seated arbitration. How do you look at, so many of us in the room are dual qualified lawyers. Which side of the fence do they fall under?
Oh, so for a dual-sided lawyers, dual qualified lawyers concerned, I think there's no problem at all. You have studied law in India, you are a bar counsel in India, this thing, you can definitely practice and advise on Indian law. Restriction is only if you don't have an Indian degree, you're not qualified to practice in India, you're not registered with the Bar Council, there is a restriction on being able to practice in India.
Tapan, now as the user in both India and England, what is your view? Do you want foreign lawyers to be in India? What is your view on the topic overall?
It is perplexing and baffling that why Indian market is not open. As simple as it. We are just going in our circles and circles. We are saying we are the fourth largest economy. We want to be a 5 trillion economy. We have to increase our per capita income. We want every foreign direct investment in India. We have opened every other sector, in defense and nuclear with some restrictions, but we don't want to open our legal practice. It is just doesn't sync with the aspirations of the nation and the performance of the nation. And one sector which is playing its own rigmarole in its own wording, in its own drafting. We all claiming, who are Indian qualified lawyers, that we are one of the best lawyers in the world, we know English, and keep on drafting these notifications and all, which none of us understand. I think we have to take a stand that we want it or we don't want it. And if we want it, I think I can identify at least 20 lawyers in this room who can draft it and all of us will understand. So I think it's baffling, and I still believe that the aspirations of India really requires, and it's not about the territory, it's about the knowledge transfer. There's a lot of knowledge sitting outside India which has to go to India. It's an exposure for the Indian students and Indian bar to come out and practice and learn. I am also a dual qualified lawyer in India and New York, and there's a lot to learn from both the systems. So I think it's, I just hope that it gets sorted soon and then we are able to grow the profession in the right way.
Thank you for that. Over to you, Sharina.
Thank you, Shivani. So we've traveled quite far now. So we started with the UK-India cross-learning section, and then we moved on to enforcement. That's where the money is. Then we moved on to regulations, and that was, I think, a very interesting piece and lots of great takeaways. I think this panel could actually just sit here and draft the rules that would work. And then we now move on to mediation. And my first question is really to Mahesh, because I know you're really big in promoting mediation and out-of-court settlements. Do you see a future, this is a future-looking question, do you see the future in which mediation is integrated into cross-border disputes, with arbitration becoming much more of an exception rather than the rule, and mediation taking over as a starting point?
I think in India, mediation would be very, very successful for one simple reason, that in India, arbitration has a lot of respect, a lot of regard. Everybody talking about ADR in the seminars and the conferences. All judges sitting or retired come here, say you should go for arbitration. There should be, but in India, when they sit on the bench, there is no respect. First thing they do is, what are the reasons to set aside an award? The name of the arbitrator, name of the parties, the contract amount is 100 crores, the award amount is 500 crores. So many reasons that before opening the file, the award is set aside. Correct? So, because in India, unfortunately, despite so many meetings, etc., arbitration is not respected so much. I think mediation is the next thing which should be welcome. And there are problems in mediation also, that how to enforce it. That is a major issue. Insofar as India is concerned, now we have a Mediation Act. Some provisions are going to be notified soon. So mediation would be recognized and it will result in a enforceable decree. Insofar as international mediations are concerned, there is still an issue, but I think that can be sorted out. If parties know that after a prolonged arbitration of 2-3 years and the challenge process of 10 years, they're back to square one, it is better to have a mediation. Only thing is that the mediation has to be well organized. There has to be a good, respectable mediator. The proceedings in mediation also need to be properly recorded, so that as and when an Indian authority, say a regulatory agency, looks at a mediation award, there is some respect. Because what can happen potentially is that mediation can be a technique of doing things which are not right. There are a lot of money laundering issues. You have a collusive award. Mediation is the easiest thing to do. So therefore, if proper checks and balances are maintained and mediation doesn't become a tool to flout the law, I think it can be very successful.
And I hope that that comes true, because that would really help with the backlog of the courts in India as well.
No, absolutely. You see, I'll tell you one more thing, that if you see the number of awards which are passed in UK in a year, more than that are set aside in India. So therefore, it is very, very critical that mediation becomes a final resolution mechanism so that parties see a resolution and go on with life.
I think one takeaway that I have from what our discussion has been is, if we push for adverse cost order and we push for mediation, you're automatically going to be reducing the backlog of the Indian courts.
That's true. And lawyers like Gaurav and other prominent people, they have to push mediation and they have to participate in mediation. It can't be left to parties to mediate. There has to be a proper professional mediation process with a proper mediator at the helm to make it sound good.
Thank you. Gaurav, our next question is to you. Mahesh has called you a very prominent person, so very prominent Gaurav. It's about AI and dispute resolution. And my worry is that, and we've heard throughout LIDW a lot about AI and a lot about technology, and that is on everyone's mind. But what happens to the human mind, and where do you draw the line between AI and the incredible human minds that are there?
It's like a philosophical question, so I'm not sure, we don't know where we're going with this. So I think on a practical level, let's forget about, the philosophy. On a practical level, we now have, we've spent a considerable time with the Chartered Institute of Arbitrators. I think if you look at there are hundreds of guidelines. UNESCO started it. I don't know why UNESCO. So UNESCO started it. The UNCITRAL has a guideline. CIR has a guideline. The Supreme Court of India 2 days ago published draft regulations, Regulation 19 and 20 guidelines. I think there are a plethora of guidelines, but the balance there is uniform throughout all the guidelines. I think the CIR test is where you draw the line. So you are drawing the line at a particular stage now. Maybe 2 years from now, that line will be different. But I mean, all this great discussion of AI is fine, but we are all using it. We're all using it, and we are all seduced by it. And all these great points about rule of law, due process, human versus AI. This is almost like that internet discussion about what will the internet do. We are using it.
We are using it, hopefully with confidentiality and data protection in mind.
I mean, no privacy, no data protection, no. Absolutely.
Sapan, question for you on the future, and this is the last question before we move to a rapid fire round, which Shivani is skillfully going to do. But as supply chains diversify and geopolitical tensions reshape global trade, what new types of India-UK disputes do you expect to see?
For us, we don't have India-UK corridor. It's India-UK in terms of disputes. But I think given how our geographical footprint is, India is for Indian work. India is not a regional center for us, not a global center for us. London is definitely a global center for us as far as the legal work is concerned. And between English law and New York law, I think I have more contracts and more disputes where English law is above New York law. And that is likely to continue. The reasons are very simple. It's a global financial center, very well developed. very high roster of law firms, depending on the cost you want to spend, experts, physical advantage that you can, it's the center of the world as far as being to New York, going to India is concerned. So I think London is here to stay, and it's basically between London and New York to some extent, Paris and Stockholm for exit sort of arbitration, and Singapore and Dubai, to our mind, are still very regional. They are good centers, but they are very regional for Middle East, Southeast, and India for South Asia. That's how we look at it, and we don't think that India is even a regional center for arbitration. And we don't even think, I may be wrong, that even Dubai and Singapore are global arbitration centers. So it's still London, Paris, United States.
Thank you, Sapan. I think of also listening to Gaurav's answer on AI, perhaps we might be seeing technology disputes quite a lot increasing in the future, maybe energy transition as well. But who knows?
I think for the tech, I think instead of the centers first, it has to, there's so many guidelines. Are you going to make an AI-based arbitrator? Talk of that. So
Already have.
yeah, so there is
Already have.
but there is
The AAA has a system.
I don't know whether you know this.
Yeah.
The AAA has a system where you pay, you put in your documents, and you get your award.
yeah, but we looked at that system, and our understanding, which may be wrong, is that there is a human arbitrator.
There is some sort
Yeah,
of.
so you put in the documents.
You put in the documents, you get the award, and there is some very not a very.
So we looked at that system for our small time contracts, the small value contracts, and human arbitrator is sitting there. The real change will come. I haven't made up my mind as an organization or personally. Is that when those awards go for enforcement, that whether courts are going to say that okay, okay, there's a human arbitrator, that's they may accept it because it's only documents which are getting loaded. You are saving a lot of time and money. And these are low value contracts, but human arbitrator, tech arbitrator or a robot arbitrator is still a long way.
I agree. I mean, we're still at the stage of.
And then you have the whole discovery, the closure, the confidentiality, the law, which law you will apply to which disclosure, data retention. So there is lot to be sorted.
Yes.
Discovery, all of us are using AI, various forms, the relativities of the word at various states. So I think it's still a long way, but the way the legal tech industry is moving, it's moving at a much faster pace than we thought. So we will have to see, but I am not sure how much it will impact the seat or center, because it will also come down to who is accepting those awards and how does you look at the physical part of it. Server is sitting in Nevada, arbitrator is sitting in London. So there are a lot of data protection, tech issues to be sorted.
Yes. In fact, there is one paper. There were 3 panels set up by Ancitral. Panel 1 was only on this, just in 2026. And there's a lot. If you're interested, there's a lot of material.
And ICC also said made a panel on the AI use. I'm sure some of you have participated.
Yeah.
That also has some significant material. But I think it still takes some time to really make change in the arbitration. I think the corporate lawyers will be the first to.
It's like the mediation also.
Yes.
I think quite effectively that if both parties by agreement put all documents, get some kind of an AI view on it, and then move forward.
I think that the basic concept of AI is for all of us is that whichever is repeatable work is easier to get into AI. And that's where the banking, insurance, the procurement contracts, sales contracts, they are repeat. All of us are signing home loan documents, credit cards without even looking at that. They're the same. So that is quick on AI. Now litigation and arbitration has a very heavy human touch. It's very specific to the jurisdiction. Even within jurisdiction, it is very specific to say the provinces and districts. Now, reading judgments in US and UK is easier by AI because there is a format. Reading judgment in India is a nightmare because every Supreme Court judge is writing in a different format. Every High Court judge is writing in a different format. Every district is writing in a different format. to train AI, it will take some time. So let's see how
Yes.
it progresses.
Thank you. Karishma, I know you wanting to say
Just-
something.
Just to pick up what all of the three gentlemen have said. So I served on the Combar AI subcommittee to advise on what judges need to know if AI has been used. For example, there is an independence that is expected of any expert witness. But if the expert has used AI, should the judge know that they have been assisted by AI? If they have only used it to analyze, make certain small analysis versus actually had the entire report written by AI. So when is it that the judge needs to be informed that AI has been used? Likewise with witness statements and pleadings and so on. But I think, so the AAA does have human intervention, which is perhaps required given how nascent we are in our AI journey of creating AI arbitrators. But for very many years, in fact, AI has resolved small value disputes for the likes of eBay. So tens of thousands of disputes have been resolved by AI, which are just, $10, $20, $50 disputes. So it is possible. It's going to require a tremendous leap of faith on all of our parts. It's also going to require large language models, which is much easier in a system such as England, which operates on one language, compared to India, where large language models are going to need to be developed for a very large number of languages as well. So it's starting, but I would agree with everybody that we're going to get there sooner or later.
The real point is enforcement, which is a point that Mahesh has. Yeah. Thank you.
Thank you. I think AI in litigation and arbitration, we can spend all day talking about it. Moving now to the final leg of this session, the rapid fire round. Mahesh, starting with you, if you could implement one legal reform in India tomorrow, which would have the most impact, what would it be?
Permit foreign lawyers to practice in India.
We're going to quote you on that. Touche.
Definitely.
Karishma, coming to you. Same question, but in the UK.
In the UK?
Yes. What is one legal reform you could implement in the UK tomorrow, which would have the most impact?
I think having junior advocates given more face time in court.
I think that's a great one. I remember when I was fresh out of law school, I got to appear before the Indian Supreme Court, which I thought is a fantastic opportunity for younger lawyers. Coming to you, Gaurav, what recent legal or regulatory development concerns you the most right now and keeps you up at night?
Already answered that question, the BCI rule. It is just, we have this lovely situation with arbitration in India. It's like snakes and ladders. Remember the old game of snakes and ladders? There's a great judgment, there's a great reform, we go all the way up, and suddenly then we go down, and we go up, then we go down. So it's so this year is the BCI rules. Next year it might be something else.
Okay, we'll have to wait for
Well,
next
that's
year.
because the BCI rules will have actually come into force.
Mahesh's prediction would have come true. Sapan, coming to you, and this is a bit of a futuristic question. 10 years from today, what do you think would be the biggest change in how international disputes are resolved?
Hard to say. I think AI is one big bet for me. I think that's really going to play out in the next 10 to 10 years. I would say next 3 to 5 years.
Thank you for that. I think now we would like to conclude this panel, but we'll open the floor to question and answers because I'm sure the audience is dying to ask this panel questions.
Good afternoon. I'm Dev Mukherjee from Ordigno and Company. Just one quick question. In terms of foreign lawyers, you see, UK is very clever in the sense you have QLTS. So you're an Indian lawyer, you come over here, you clear the QLTS, no disputes. I think it's a revenue generation model also for India if they do a similar QLTS in India, and that will dissolve the dispute. What do you think?
Mahesh would be better placed to answer that. I think, I don't think revenue generating model will satisfy the Bar Council of India. I think they have many constituencies to look at and a larger picture to look at. But it's a great idea. We can pitch it to them. Maybe that might be a sword to cut the Gordian knot. I hadn't thought of that. That's a good system. I think it just solves one of the objection of reciprocity, but it's one piece of the puzzle. And the legal profession in India goes to the villages and the towns. The one step you make, are you putting the local bar at risk? And local bar is politically very influential, and they wouldn't want. I wonder, would you ask a KC from my chamber wanting to do an arbitration? Just a 5-minute aside and do the QLTS. So now that'll work. Will work for the newer talent, but just answer the reciprocity. Yeah, I think that's a good idea. Certainly worth thinking.
Any more questions?
Hi, Sean Madan from Mandelbaum Barrett in New York. We have some influential people, especially Mr. Banerjee, Mr. Agarwal. I practiced for about 8-10 years in India and then moved to New York, and I had to unlearn a few things and learn afresh, and I think it helped. Why can't we move towards, and this goes to the point about pendency, and of course you said, welcome foreign officers in India. Why can't we slowly, gradually move towards a system of brevity? Limit page numbers or pages.
Very easy answer. I think very easy answer. I mean, everybody's tried it. Courts have tried it. We have an oral tradition. We like the sound of our own voices. That's the reality. The emphasis on written work is discounted in the West, and you have to unlearn. And in arbitration, and whether Singapore, London, New York, the written word is very important. Language is important. Precision is important. Then you have a situation where oral hearings are short. But the reality is, in our courts, they are overwhelmed. You cannot expect an Indian judge to be like an English judge, to have read all the papers. So the value attached to written pleadings is much less than your oral argument. So I think the dynamic of the country with the volume is that it is an oral tradition. It is very difficult to, it obviously, you're right, it is the way for time limits, written submissions. It is, I mean, I do not see it happening. That's the reality.
Problem is there's so much wastage of time. 3 weeks, 3 days a week for 4 weeks, same matter, the amount of time that's spent on it, judges forget everything. And anyone worth their dime, and on miscellaneous days, you get the reliefs, but in 1 minute, in 3 minutes.
How do you get out of that? I don't know. I think Dr. Pinky Anand has an answer.
Perhaps a pilot project, commercial courts, somewhere starts so that it becomes a trend. It shows its value, it shows its worth, and then we need to be ready to welcome the foreign force.
Pallavi.
My question is to Sapal. What are your expectations from external counsel, since both in India and UK, since a lot of them are there in the room? And when do they boost your confidence?
I think this is the $1 million question.
It's just for the English audience, is like solicitor for us. And Gaurav is barrister for us in India. And Mahesh is telling in my ears that ask Gaurav to reduce the fee. And I fully agree. On a serious note, I think the Indian bar is pretty effective. And I think they have kept pace with what's happening in the economy. We haven't really faced that there is a difference in the quality of lawyer. Yeah. Here on in that sense.
the Indian economy has increased at such a pace that there are not enough our senior advocates in Supreme Courts and some of the leading high courts. And I think that system has to really improve. That has the economy and the litigation of high values increasing. We need to have more senior advocates or barristers and senior. And I think in UK, it's the best bar, probably the best lawyers. But sometimes we don't find them aggressive. We do have that debate with our panel law firms. Some agree with this view, some don't agree with this view. And one of the reasons we believe, again, I may be wrong, but that's why the US law firms are doing well in UK. That the US lawyers are more solution oriented, more business minded than UK lawyers. And our expectations are broadly the same, that we need lawyers with high integrity. Understand the integrity is very, very important. And then to an English solicitor and all the integrations, it's never been an issue. Go down in the jurisdiction. Like in Indian law firms, conflict remains a concern. UK law firm conflict has never been a concern. In a US law firm, it has never been a concern. So the Indian law firms have to manage their conflict clearly.
There's no system of conflict.
There's no system. People, when move from one law firm to another law firm, they don't keep record and they say no. And people, so there is a lot to learn. And the other thing which we would expect Indian law firms to do is the training. The training system in US, the solicitor training system here in UK is very good. Law firms invest in them, spend time in them, make it compulsory. So two things, if I have to see, I would say is the management of conflict and training their own lawyers. I think the global law firms are far ahead of the Indian law firms.
Thank you, Sapan. I think we have time for one final question. Okay.
Yeah, hi, my name is Pallav. I think it's less of a question, more of a comment on the cost issue which you raised before. I think the reason why India can't be a cost jurisdiction is because there's lack of certainty in Indian courts. A lot of time we have conflicting judgments. Indian courts are basically equity based. The judges want to give relief to appeal against the government. So they find ways out, they find exceptions. And that adds a bit of a certainty issue in India. And that is why I believe a lot of time as lawyers, we also advise, let's take a chance, let's do this. And sometimes it works in the worst of the matter. So I believe India is a little bit far away from being a cost jurisdiction to that extent.
Okay, one final question, I think, in that side of the audience. Would you like a mic?
I think I can get out of that. My question is to Gaurav. When you discussed about litigation costs and the mentality of Indian judges, don't you think the fundamental issue is delay and tendency? And that is why the costs increase, and therefore judges feel that why should a party burden with extra cost?
I don't know what solution there is to delay. I mean, if you have a solution to that, I think we could get the Chief Justice of India here. But maybe that I don't think it's a delay and costs equation. I think judges just see those numbers and have the reaction that Sapan had about 40% reduction of fees. So I don't think judges who do not come from commercial backgrounds are comfortable awarding fees at the actual or the rate at which you actually lose or you actually spend. So I think there is some hesitation in doing it. Even though all the rules may be in place, there's some hesitation in doing it. I don't think it's just a question of delay. I think even with the delay, the costs are not that big as they are, let us say, in this part of the world. You know, it's just that you've never, as a judge, ever encountered so many matters like this. You suddenly are faced with a huge claim with fancy lawyers and huge costs. You can't find it in your heart to, there's some socialist element there. You can't find it in your heart to award large sums of money.
Anything from you, Karishma?
Oh, no.
Okay.
Offline.
All right. Well, thank you to the audience and thank you to our panelists for a very, very insightful panel discussion.
And a big thank you to Shivani for hosting everyone at BCL.
My pleasure. And thank you, Serena, for co-moderating with me.
Shivani,
I was told that you were going to be here.
I was very willing to give you, but I saw
Travel in Delhi, just let me.
And I broke my
May I request everyone, please? Hello? May I request everyone to be seated, please? Because we are just starting a third session, which is on legal reforms. अच्छा तो फिर बाद में सेशन
हमारे आप लड़ाई हो गई.
So we are just starting with the next 5 minutes, please. Request everyone to be seated, please, and we are just starting in next 5 minutes.
What do I want? Tissue's here. He's got to shoot off at 6:15. But if you want to have 5 minutes, I think I was so nice. Questions, everything else from first instance. Forward to Thank you so much.
Our esteemed supporter.
Exactly. In Hong Kong, Mohammed Talib.
Thank you. Excellent. No, I'm saying. Investment training. I mean, that's my relevant.
Since you mentioned US reference.
No, I haven't had
One of our they want to
Okay.
But when you have states involved, it's like it's yeah. So I sit within no, I guess it is right, but I'm basically sorry.
Your hand, right? Showcase. Showcase.
Come on.
Firstly, take a moment. Yes, please.
To be able to say the things you were saying. Looks like like you
Like I was, I don't know, like I haven't seen much of it. Yeah, that's what I was about. You said, that's what that was the meeting
How are you?
Yes.
Such way now.
Unmuted.
We haven't met.
I'm a big fan.
Where are we sitting?
This one, I'm just telling him.
Yeah.
I think people have had a long panel. Now they
And then you just talk through like this.
No, much better.
No, that was 6 weeks. It ends in about.
I'm coming back.
And it's on, yeah, okay, yeah.
Spotlight on you, I don't think. No, but I would like it.
Nice to meet you.
I wish I was.
Sitting in the middle. Where are you sitting? Right in the middle. The question is how short it's already delayed. There we are.
I don't know. Yeah, that's it. That's the details. Never not.
Right.
That's why.
How do you? It just is 1 year. Remember it. Yeah.
Yeah.
Release is a WhatsApp. 1 year. Only
Get a coffee and then. Yes, yes. Let me give you my experiences. Somebody was just telling me you should have 4 markets, one at each. Obviously, I haven't done the gold mining case. Yes. Yes. Thank you. If to ask them, are they happy to hear us for long or do they want to shut us? Yeah, please. Where should I get it?
My husband is Nabatpur.
That's fine. It's not that. Yeah, this is what you are. So it's done.
There you are.
So I just need a picture.
Okay.
Just have the no panel better.
Amazing, thank you.
Thank you.
Picture with you all.
Yes, please.
I'm coming.
So it is there. What is this privilege and all?
My inspiration is there.
Maybe
My inspiration is there, so I'm happy.
Very and so it's much nothing by friends university. That's impression. Yeah.
Yeah.
And the reason why I mentioned when you sort of searching there is I just about to
Yeah, so I just found.
I think we should. And I think we should try to restrict it. We should try to curtail our. I don't think it's nobody is interested in hearing for 1 hour. It's cut short.
You know, it's going to give some question time.
Sorry?
We give some question time.
Yeah.
You ready?
Yeah.
As you can see, we are more.
I won't kiss it, yeah.
We are more keen to go for the cocktails.
Yeah. Yeah, of course.
Yes. So.
Oh, right.
We can speak.
I think we should find
I'm in London.
For a short argument.
Okay.
यहाँ भी देखो सर they have to do that आपको पता कहाँ देखते हैं मैम
To become professional is terrible.
like that too the telegraph quite taking that was going to be the question. When I first came, I think पहले बोले थे वो That's before the city.
Hello again.
All right.
I'm responsible for the solicitor.
Oh, yes, yes.
I'm that individual, that's my comment. So you remember you requested.
Yeah, yes. And I think you got my response.
That's long.
I love the side. I love the side.
And I wish I'd known you were here, I would have given you the 2 books.
Oh, fantastic title.
Yeah, really interesting. They're all perspective.
Now,
So that's why I'm
So I see that one. And it's in
And we come in admission ceremonies.
I saw that once and that's
Next time I get you.
Hi, Practitioner Vice President. Yes, we have been. I said your youth ambassador.
Oh, yeah, what's that?
Conclusion when they asked me about it. It's had a great time. I took them around the library, like night to the museum. Yes, that's right. So I think and I get to I might not have a chance to catch up with you, but
Good evening, everybody. May I request everyone to be seated, please? We are highly privileged and honored
I have to address
that the Right Honorable the Lord Hummer KC, Attorney General for England and Wales, is with us. Welcome, sir. We have also representatives from the British High Commission. We have also representatives from the Trade and Commerce Commission also. We have highly privileged that Brad Dixon, Vice President of the Law Society of England and Wales, is also here. Now, may I request, without wasting your further time, may I request Right Honorable Lord Hummer to deliver his speech as chief guest of this function, please. Thank you very much.
Good evening. Thank you all so much. Can I just start by firstly turning on my microphone? And secondly, just saying what a reflection of the extraordinary commitment of all of you. I don't think I've ever been to a legal event in which a session was about to start at 6 p.m. on a Friday. Look, I know it's been a busy time at the London International Disputes Week. I very much hope guests from India here have enjoyed all of it. I hope you've also had a time to enjoy our wonderful capital city, London. Contrary to some things you may read on the occasional social media feeds from some of our friends, this is a wonderful city, a vibrant, diverse city. And I very much hope, apart from law, you've also had some fun. Can I also pay a special thanks to BCLP for hosting us, the Law Society, and of course the General Counsels Association of India for bringing together such a remarkable group of lawyers, and to provide a forum to discuss the defining legal challenges of our era. Now, last year was a huge year for the special relationship between our two countries. We had two prime ministerial visits. We have the launch of the Tech Security Initiative, the signing of the Vision 2035, and a landmark trade agreement, our most significant bilateral trade deal since leaving the EU. And just this week, two of my very good friends, Foreign Secretary and the Business Secretary, have been in Delhi, continuing this important work, binding our nations ever closer together. And I've no doubt that the conversations that have taken place today will be another important step on that journey. We're sharing ideas, we're sharing insights and innovation on how we confront not just the challenges we face today, but the challenges that present on the horizon. And I hope you found today productive. I'm going to have to make a little confession, which is whilst you've been working hard this afternoon, I did escape for a couple of hours to Lord's, which is often called the home of cricket. And somewhat surprisingly, at least when I last checked on the way here, England seemed to be playing quite well. But I am deeply conscious that mentioning in cricket in companies such as this requires, shall we say, a certain degree of humility. And indeed, last summer, watching Mohammad Siraj dismantle our batting lineup at the Oval reminded me that whilst the partnership between our two nations is based upon reciprocal respect, our sporting prowess is not always one of equals, but we're working on it. Cricket, of course, is more than just a game that we both cherish. It's a form of institution, and it has a reflection in the institutions that we are building today. We are two countries with huge respect for each other, huge respect for the rule of law. But more than that, we have a distinct understanding of how that translates to the stability required for our societies to grow and for our respective nations to prosper. Because what our rule of law culture provides is the degree of certainty to businesses in order to be able to flourish. That is part of our joint traditions. We believe, as in cricket, in the rules of the game. And we understand in today's globalized economy that nations that respect the rules of the game are nations that prosper. Because certainty, and the certainty that adherence to the rule of law provides, is the bedrock of businesses flourishing. Whether domestic businesses, international investors, it provides the stability, the assurance that rules will be followed, that institutions can be trusted, and that disputes, when they do arise, as they inevitably do in business, will be resolved fairly with independent adjudication. And we can see the real world benefits of that. In India, an outward-looking country with becoming one of the economic powerhouses of the 21st century, on track to become the third largest economy in the world by 2028. And here in the United Kingdom, we're responding to the same challenges with renewed purpose, making economic growth the defining mission of this government. We're doing so by putting trade and international investment at the heart of our government's plan to drive that growth across the whole country. And that's why last July was such a significant moment for us, because we signed the UK-India Comprehensive Economic and Trade Agreement. And its benefits will be shared by both our countries and by the people of both our countries. It's expected to increase trade by £25.5 billion annually in the long run, creating new opportunities for businesses on both sides and cementing one of the most important bilateral relationships of this century. The trade agreements are only as strong as the foundations on which they lie. But this one is built on trust. It is built on stability, not a given in the world today. Predictability is now one of the most valuable commodities that anybody can offer. In fact, it is a competitive advantage. It's why here in the UK, we remain one of the world's most open economies. It's why I can say proudly as Attorney General, our legal system continues to set global standards. And if I may, in this context, the Bar Council of India's regulation for foreign lawyers are at a significant juncture, not just in our bilateral relationships, but India's legal powerhouse and its relationship with the world. A signal that India intends to play an even greater role at the center of the global economy. And of course, global integration with the international legal market doesn't simply benefit lawyers. Of itself, it provides a catalyst as part of a synergistic relationship with trade and investment. It underpins efficient dispute resolution. Look, ultimately, it makes it easier to do business. So let me conclude with pleasure by reaffirming the United Kingdom's commitment to our partnership with India that we believe will shape the decades ahead. The opportunities ahead are enormous. And I have no doubt that the lawyers, general counsel, and the legal professionals in this room will be at the heart of seizing it. I hope today also serves as a celebration, recognizing how far our relations have come, but what more we can achieve together. So thank you for your time, for your expertise, for your commitment to the legal partnership between our two great countries. And as for cricket, subject to what I'm going to look on my screen in a moment, this country remains as optimistic as ever. Thank you. Enjoy the rest of your evening. Thank you so much. Forgive me for that. Oh, wonderful. Yes, please do. Oh, of course.
Yeah. So this is the book on Nyaya Nirman, which I'm presenting to Right Honorable Lord Hammer.
Apologies that I am dashing, but enjoy the rest of the session. Thank you. Sessions. Thank you so much.
Good evening, ladies and gentlemen. I know we are running late, but we try to see and make it as interesting as possible. This is the last panel. Let me start first by congratulating GCAI for holding another very interesting and very apt conference, and of course BCLP for hosting this event. Today's session is all about building the legal ecosystem for Viksit Bharat 2047, governance, inclusion, and institutional innovation. Viksit Bharat, or Developed India, is a vision for transforming India into a modern, prosperous, inclusive, and a sustainable nation by 2047, which also marks 100 years of independence for India. Of course, as India looks at 2047, the conversion is not only economic growth or policy ambition, it is also institutions, and in particular legal institutions that are credible, efficient, accessible, and internationally respected. I mean, all of us understand what it means. A strong legal ecosystem is fundamental for that vision. We've heard earlier panels speaks about the challenges which India at the moment faces with backlogs, etc., about enforcement and therefore this becomes a very important thing. We are, of course, very, very fortunate to have such a distinguished panel with experience across litigation, arbitration, advisory, international disputes, and institutional leadership. So I'll just take a few minutes to introduce the panel, though they don't require any introduction. But let me do that in any case. Let me start with Pinky Anand. So their profiles are, if you start talking about their accomplishment, it'll run into many pages. So what I did, I used AI. So just to get a couple of lines which could, so if I don't, please, it's all about AI. Don't catch me. So Pinky Anand. Dr. Pinky Anand is a senior advocate at the Supreme Court of India, a judge of the Bahrain International Commercial Court, and former Additional Solicitor General of India. Her career uniquely combines public service, constitutional advocacy, and international adjudication at the highest levels. That's AI. Not bad. Very good, I thought. Then let me introduce you to Philip Wood.
Mr. Philip Wood, CBE, KC, is one of the world's foremost authorities on international finance and commercial law. For many years in this room, his books are not only merely recommended reading, they are required reading. And then we have Geeta Luthra, who is Vice President of the Indian Council of Arbitration and a senior advocate of the Supreme Court of India. For many in the arbitration community, she has been both a participant in and a witness to the evolution of arbitration in India, while also helping shape its institutions through her leadership at the ICA. I had Mr. Harish Salve's introduction also, but last minute, unfortunately, couldn't make it. I have the next introduction I would like to make is Iris Sovanak, Senior Associate Hogan Lovells, has an international arbitration practice and focuses on public international law and investor-state disputes. Her work spans the representation of foreign states, international organizations, and private investors. And I was informed by her that she's at the moment representing India in some of the disputes. Then I have on my left, Karthik Singh is a leading member of Baker McKenzie's dispute resolution practice and a highly regarded arbitration practitioner. His practice spans both international commercial arbitration and investment treaty disputes, with experience across multi-jurisdiction industries and arbitral institutions. And last, not the least, I have Divyam Agarwal, who's a partner at JSA and is one of India's leading arbitration practitioners. His experience spans some of the country's most significant infrastructure, energy, and shareholder disputes, reflecting the evolution of arbitration into a mainstream mechanism for resolving commercial disputes in India. So GCAI gave us, as you could see, the several pointers on what our discussion should be about. So I'm going to try and stick to that. And I will start with Pinky with the first question. So first question, which is very critical for India's, from Indian perspective, the way the law has been developing across, is corporate governance and regulatory reform. So the question to you, Pinky, is do you see stronger governance standards and materially improving the enforceability environment and making high value commercial litigation, or does the challenge lie more in implementation and adjudication?
It's a vexed question, but the answer is quite clear actually. They're actually not linked to each other. And what you really need in terms of corporate implementation is in fact the process itself of implementation. Because what happens is that is what is needed when a dispute arises. Before that, all you have is, and what you need, and we have done a lot of that, by the way. Having said that, in the sense of governance in the corporate world, because of commercial disputes and the commercial interaction between not only UK and India, but between all the countries, what we have done is immense kind of compliance issues. We made it simpler. We made single windows. We've come up with the IBC, the Insolvency Code. We have done away with criminalization of corporate laws. So we've made it ultimately amenable to normal civil jurisdiction rather than penal consequences, so that you're not afraid of it, but you have to comply with it. That's not the matter. So overall, we have tended into a lot of domain. But at the end of it, that is pre-dispute arising. That is to ensure that the system works. But when the system is let down, in a sense, that there are disputes, and there will be disputes. Wherever the world is there, and the corporate world is there, and the commercial world is there, come what time, when you will see that happening, you will continue to have disputes. So the resolution of disputes itself is not as much to do with the governance policies as to do with the implementation policies. And of course, you've heard a bit about India having a few of the issues. I mean, frankly, all countries have. It's not that all countries don't have. And we do have a wide range. So, I mean, we have 80 matters a day. You have 30 matters in a year in the Supreme Court. I mean, that's the kind of divergence that we have in terms of figures. Shivani was speaking about in the session before. So there is a tremendous amount of reason that we have to see that. And honestly, there's another problem. We followed your 1908 Civil Procedure Code. So we follow the procedures through like absolute efficiency goes. So we want to kind of divert away to that to make it little milder. In arbitration, for example, you also have a situation where you are constantly grappling and importing all sorts of civil processes. We have to do away with that. In fact, that's the talk of the morning also, that basically we're making arbitration as if it is a second litigation chamber. It isn't. It was never meant to be. And the reason we came to ADR was so that we could do away with the formalistic processes and to come to an easy resolution by having less requirement for pleadings, for discoveries, for experts. Yesterday, only in a matter, in fact, he declined the expert from both the sides. He said the tribunal can call for it under the Arbitration Act, but the parties can't call because all you'll have is two varying versions. At the end of it, you still have to decide. And what we finally held as arbitrators, the tribunal held, was the fact that we had the expertise, we had a technical member also. We had the expertise to decide what to do, and the pleadings are there before us. So that's the end of the matter. Because the minute you introduce a new process, you firstly increase the time, then you add in another tier of adjudication, either now or later, whatever the process might be, and that goes on into another tier and another tier. So you really have to look at the efficiency levels and say, we have come to a time today, we need quicker disposal. The maximum requirement in a commercial dispute is the fact that you need speed, because you can still withstand some costing. I've seen some companies which have actually declared litigation or risk analysis as a cost within their costing of the project. But what do you do with delay? If you have 10 years, for example, a matter which is carried on, how are you going to carry on your work to finish the project, or to walk into another project, or to, in fact, compute your damages? Everything is a matter of time within that. The time, I think, is a major feature. And to that, we need the implementation in a much quicker way. And I do believe that, I mean, much as we lag behind in some ways, I'm not sure that it works even more efficiently in UK. I do believe even here there's some requirements, but this is not about countries. This is about the global world. And the enforcement process in arbitration, in international arbitration, is the one which vexes the most. Because multiple jurisdictions, multiple assets located in different jurisdictions, and the public policy exception in the New York Convention, which continues to rule us and follow us like a ghost. We do have to understand and to try to put down not a UN kind of limit, but some kind of practical limit on that, entertaining that disputes in that respect.
But you would say that in the last 10 to 15 years, we've seen a tremendous amount of compliance, corporate compliance come in. And, there's been substantial improvement. Though, of course, having said that, from yesterday, we have this news of a company called Rajesh Exports, where it seems to be there is $158 billion missing. And how could that have happened with major auditors and, SEBI coming out with this, which is quite amazing. But, if everything you will have once in a while.
Human mind has the most possibility of doing the worst and the best. I mean, it is ingenuous. It's better than AI for sure, whatever AI may do for us. So having said that, you're right. We have entered into a large area of compliances in all ways. In fact, I'll tell you, so many of these people who did not do compliances are in this country today and being kept back by the government. So let's face it, all of them were compliance issues, by the way. Had the compliances been done, had the compliances been followed, red flagging was done. Nonetheless, they escaped to come here and for the time being receive the patronage in this country. But compliances, yes, we have indeed ensured, and in fact, we have an entire culture in the legal firms and the corporate firms to have a compliance cell, so to say, and lawyers only looking at that issue. So I think compliance is really, we've gone a long way into the corporate world, and even the insolvency code. I say that even now because I think insolvency code is important, but for example, one of the issues, we haven't entered into a treaty for cross-border insolvency. So therefore, when you have assets, you have creditors all over the world into different jurisdictions, what do? We are still awaiting that. So that we do, yes, need to fast forward. Another area which I will mark, even though the last session I really wrote that down, is mediation. And particularly our friend from Arcelor, he did feel that mediation was really a non-starter in any respect in commercial disputes. But having said that, again, we've come into a big way into mediation as a process for taking care of the backlogs, for taking care of the commercial disputes resolution in a time-bound period. Because really, any adjudicatory process, the common law is very good, but the common law also obsesses the due process. India obsesses even more. We think we just have to justify due process of law, which is very good, good to talk about it, but it takes a lot of time. And in today's world, you kind of have constraints in that direction. So as I said, we have gone, and even decriminalization. There has been a trend over the last 10 years. I remember working on this entire project from 10 years back. And from time to time, we kept reducing it. So you comply, you don't comply, there'll be a penalty, there'll be a huge fine. That's fine. But no criminalization. So you are not really put behind bars for that purpose. Let us sort it out in an educated and a commercial world as it is today.
Thank you. Let me come to you, Philip. This topic, which is, I think, one of the most discussed and one of the most debated in India, the ease of doing business in India and compliance situation. Again, it gets connected to compliance. We are ranked 63, if my memory serves right. But I think being a FDI inward-looking country, we need to probably keep improving that. So the question to you is, from a comparative legal systems perspective, what typically distinguishes jurisdictions that are genuinely business-friendly from those that are merely well-regulated on paper? What's your view?
I like that question, by the way. I mean, it's really quite a small question, isn't it? But I'll answer it in perhaps an unusual way, if you don't mind. First of all, sometimes we need to draw back a little and see the bigger picture, what we really trying to do. And my view of the lawyers and what you do is that the laws as a whole around the world are the biggest and most comprehensive codes of conduct which humanity has ever produced. And they are essential not just for well-being, but for society survival. So, for instance, you couldn't really have a democracy without laws. You couldn't levy taxation, because a lot of people like me, wouldn't pay tax. You wouldn't be able to get people to pay their debts. You wouldn't be able to operate a contractual system. You couldn't operate even at the most basic level in having inheritance. In my view, without laws at all, I mean, no laws, no faculty of law, no judges, no police, none of that, we would live in a situation of chaos, of anarchy and mayhem. Now, a lot of people think that nowadays, actually, we don't go around murdering people and so on. We wouldn't, and of course I understand all that. But in these vast, anonymous, urban societies we have got now, there are quite a lot of people who would not perform according to Rousseau's idea of the mutual contract, which we have, which is the base of the law. So I start with that proposition. And to me, that proposition it's a platitude. It's a self-evident truism. But it comes across as revolutionary to a lot of people for reasons which I'll mention in a moment, so far as I can see. Because, for example, to some people, say on the far left wing, they don't like the laws because they regard them as a system of oppression, which is imposed on them by the elites. And then on the right wing, you get people who don't like human rights and all this kind of stuff. And so you get people who basically saying, there may be codes of conduct, but we don't like the codes of conduct, which we've got. And my answer to that is they still are the codes of conduct. And if you don't like them, then change them. So if you say, if they are these codes of conduct, then the question is, which you're asking, what is needed in order to make them suitable to, I think basically you're saying growth. And obviously that is a choice which societies make, because these codes of conduct are a kind of ideology, and they represent the ideology, the credentials which a particular country has got. So when I talk about the idea of ideologies, I'd like to show you a map. Would you mind holding this up, please? This is a map which comes from about 1998 or thereabouts, and I've been refining them. These are the jurisdictions of the world. And you see that it's quite gaudily colored. And it's of enormous interest to me because it reflects the great families of law and where they come from. And the way I work it out, I use key indicators. You know, I take an indicator, which is a technical matter, and I drop it in the legal system to see whether it comes out blue or pink, you know. And I use about 70 of these to work out what families there are. And together, they are quite, to me, fantastically accurate. You can really pin down what the jurisdictions are. And according to my calculations, there are about 320, just under, maybe a bit more. You know, the arguments about Kosovo and Gaza and so on, as to whether they're separate jurisdictions. And out of those 320, just under 90% are based upon one of the three big families, which are the common law, the Napoleonic, the Roman Germanic, or a mixture like China. I worked out it's about 89.2% altogether. Now, out of those groups, I might say that we're very, very grateful to you all here in England that we've got such a large population in India, because you are a member of the, you know, whether you sort of like it or not, I think perhaps don't like it, that you're a member of the common law group, which is a very large group. And basically, in terms of the number of jurisdictions, I reckon it's 40, 30, 20, the rest. 40 is the common law groups, which of course includes the US states and yourself and a number of other large countries, and then some very small islands, you know, like the UK and Canada. And then the 30% are Napoleonic based, and basically France and Spain. And then the other 20% are based on Germany with a number of other countries like Holland and Switzerland. So those are the group. And then you have these big mixed jurisdictions like China. And then the other groups are basically the ex-Soviet countries like Russia, Kazakhstan, Uzbekistan, and so on, the Islamic group, and then a number of what I call unallocated groups like the Vatican, you know, the South Pole and Cuba and places like that, North Korea. Now, the effect of that is that if you apply my credentials of these groups were formed in the 19th century, at the time of the Industrial Revolution. At the time of the Industrial Revolution, it made a tremendous leap forward in the way we think about law. I mean, to me, the Industrial Revolution was much, much greater than the Agricultural Revolution. It came quite late, and it completely transformed our legal system and corporations, regulations. Everything really kicked off in the Industrial Revolution. And the result of that, do you mind sharing this around? Those are the three main groups, which I work on the basis of various criteria, which these are only 5 of them, as I say, I use a lot. Now, the blue are common law. The red are Napoleonic. The one in the middle are Roman Germanic, on my criteria, which are very technical. As I say, they are very efficacious, and I've sort of proved. Now, if you say, what does the blue represent? It represents an incredible thing which happened in this little country that I happen to live in, which is in the 19th century, there was an attitude here. You know, they found the steam engine, and so they had all these railways and all that, but they had a view about society which is represented by Adam Smith, you know, the invisible hand of the market. And to them, capital is king, you know, the railways must be built. That was a real attitude. They didn't care about anything. It was covered by a sort of Victorian morality, if you like, prudence and a strength of purpose. But that was an attitude. And it was that attitude which represented a growing economy, a developing country. Capital is king, you know, banks do what they like. You know, that was according to my criteria. Now, the really interesting thing now to me, which is, I think, part of the answer to your question, is what's happening now. Because if you look at, you know, your competitors, if you like, the people who really started out, I mean, this country started out changing and transforming your legal system to suit yourself after 1947. That's when you began the process. Meanwhile, China started out changing the legal system under Deng in 1978, and the Russians started out under Yeltsin in 1992. Now you see actually what's happened to all of these, because in each of them, there was a classic, I mean, just to me, a quite amazing difference of what actually happened in terms of this thing here. For instance, Russia got everything wrong under this. They didn't adopt any of the Industrial Revolution things. A lot of people don't like the Industrial Revolution, I guess. They don't like free markets. Okay, I understand. But they got them. They didn't. They got very tied up in oligarchs and all sorts of confusion. You know, they couldn't even work out you need a trust these days for custodianship at the most elementary level, or a clearing system. The biggest trust in the world is the American clearing system. Secondly, China, to my amazement, and they don't like it when I say this. By the way, I don't know if you know, there's a law firm called King and Wood Mallett. I apparently am the Wood. I think they were just looking around for somebody. I'd written a book which translated Chinese. I have said to them, you know, where are my royalties? So say anyway, that was Joe Wood of Stockton-on-Tees or Birmingham or something like that. Anyway, they basically, the Chinese, the amazing thing to me is how they were sort of codifying English law. I mean, it was amazing. They had the trust. They had a wide universal fixed and floating charge, sort of. They had set off on netting on insolvency, which 2/3 of the world didn't have. And so they were going down that route, which we have. And you say, isn't that extraordinary? Where did they get it? Well, of course, they got it. They were influenced by Hong Kong, and especially Singapore was very influential in the formation of the Chinese legal system. So why would they do that? Because they were a developing country. And so was England when it went through that industrial revolution. So it was normal for them to have that kind of thing in their mind about having a business-friendly, you know, if you like, a capitalist system. So that's how they ran. Whereas in Russia, it was completely different. So the question remains for you as to what you do now. And so when I look at your legal system, without going in all the technicalities, I have to say, I think you're getting it right. I really do. I can just see what you're doing. It is a, you know, it is a growth idea. I know you probably don't agree a lot of things which are happening, but I can see underneath. That seems to me what ambitious India is doing. Now, there is and I'll just conclude with this remark. Your country is a legal powerhouse. You're going to be the most populous country in the world, and you're going to have this enormous economy, and you've got a lot of competition around. And so what have you got on your side? What is it which is somehow defining you, which is different from some of the other countries? The most important thing you've got, apart from industry and diligence and productivity and the desire to succeed and competitiveness and innovation, all those things the economists talk about, underneath, you've got this optimism. You know, underlying it is an optimism about yourselves, which translates in terms of when we're talking about codes of conduct, what you think your credentials should be in terms of your civilized law. That translates into a sense of hope about humanity. In other words, in the battle of whether you think that we are miracles or beasts, you think that we are miracles. And it is that kind of hope which transforms what you're doing and which transforms the directions I believe this country will take.
Thank you. Thank you, Philip. What a beautiful answer. With that, I wish I think I'll ask some more questions. I think maybe we should get you before the Bar Council of India also. Geeta, digital courts and access to justice. I mean, you've seen it all. You've seen how the courts have moved more towards digitization. Of course, you heard the earlier panel talk about AI, and we have heard, Justice Chandrachud talking about how to, it was very interesting when I heard him last time speaking at a conference, when he said, why don't we use AI for smaller claims and clear up all our backlog? So how do you see it? How have the courts adopted? What are they doing? And how far, I can't but ask about AI.
So the first thing is that, to my mind, Justice Chandrachud was one of the people who in that sense had a vision. And because of that, and we had COVID also at the same time. So COVID and vision. So we had video conferencing and VC hearings going on paper, at least, to every small place within India. I think that's a very big ask because he tried to secure that this would go to every common man. And to a large extent, I think he was successful. So there would be at least 80-90% courts which can have VC access. How the courts receive VC access after he's demitted office is quite another. Because there'll be courts and courts. There'll be courts who are very open to VC access, and there'll be courts who are reticent to it. You'll have that issue, and slowly, I believe, it is coming there, it's coming in evidence. And so we have to look at, now I want to look at evidence in arbitration, evidence in trials. How much do you have access video conferencing and evidence through video conferencing? One of the first things we learned as law students was you should be able to see the demeanor of the witness. You should be able to see, is the witness shifty? What's his conduct like? This is an aspect you probably won't be able to capture on video conferencing. So I believe that what are simple cross-examination, simple evidences, not too complex, should be able to be done on VCs. And so we've reached there. How much does this reach to the common man? The question is, you have AI, you have video access, but how much does it reach the common man who doesn't have a smartphone, who doesn't have an iPad, who doesn't have a laptop? India is a country with lots of diversity. So you'll have a person, there were times in COVID times when people were told, you must be giving your location. But those people didn't have phones when they went to their villages after COVID and went from jails, got bail. They didn't have devices by which they could show their location. Their devices weren't smartphones. So they had this problem. This is an issue which we in India need to address. So we want people to be on VC, but they may not have good internet in their area. There are many, many issues. We've gone a long way. We're doing very well. Now, one of the issues where I feel we've done very well is in, for example, translation. So the Supreme Court, and this was more during Justice Chandrachud's time that it started, we have so many languages, and just law has been the prerogative of the privileged few. Now it translates to those who don't know English, who know only local languages. So if you can translate some reports, some legal articles, you are actually taking law to the masses. I think it's not just for the lawyers. We have to think about the ultimate common man, the client. And in that sense, translation would go along. Now, take transcription. Now, while we talk of digitization, we are not having transcription in our evidence. So that's one of the basics, I feel. You want transparency, you must be having transcription. So those are aspects where we have to work. And while I talk about transcription and evidence, again, perhaps because I do some trial work, it concerns me that electronic evidence can actually be extremely manipulated. And the tests that we have laid in India by 2 judgments or 3 judgments are not strong tests. And that exposes us to misuse, to fraud, to having manipulation of records which may not be detected.
That's a big problem because somebody was mentioning about AI being able to change the WhatsApp transcript. Now they can do that,
They can do it, they can change timestamps. So you have to work at it very cleverly and very intelligently and very deeply. Sometimes we don't do that. And I feel that that's probably an issue. We just need, for example, in India, it was under the old Evidence Act, we had made an amendment to bring in 65B. Now it's called 63B, but it doesn't matter what it is. The question is, you give a certificate to that effect that this is a true copy of the, and that this actually happened. And the courts mostly accept it. This can be open to a lot of misuse, and I believe that that's something on which we need to concentrate. So thankfully, the Supreme Court, yesterday, we have draft regulations which have come out on artificial intelligence and the use of that in the courts. And one of the takeaways is that you have verification, which puts the responsibility on the lawyer, the person who does the filing, not the AI tool, and the duty then, in case the court asks you, to disclose. So these are very many aspects. They've asked for 20 days of people giving comments, suggestions, but at least it's a step in the right direction. And I believe that, yes, things have improved. And I've said this earlier also, that maybe motor accident challans, maybe small negotiable instruments, dishonor of check cases. These are something which may be able to be solved very much faster, easier, more mechanically with the basic data fed into the devices. But again, we have to be very careful. And I think caution seems to be, you have to forge ahead, but with caution.
Thank you, Geeta. With that, Karthik, on artificial intelligence, how do you feel that, how far can you use AI, especially in international arbitration? Of course, case management, but can we go further, and what's your personal experience?
Of course, and thank you, Nusrat. Thank you, Dr. Gimawat and the GCAI team for having me here. Well, I can see the sun is shining after a week of rain, so I will make sure I keep this short and say it in a way that the AI overlords still like me in the next description that's prepared about me. So, I mean, when preparing for this question, I briefly looked up our LIDW lineup of events, and it's a long list. And I just searched for artificial intelligence or AI, and there were almost 60 or 70 events. So I will attempt to not repeat or summarize, but in that same vein, and nor can I say something original because it's so well canvassed that we have heard about it today as well. We know that last year the Queen Mary survey came, in which 90% respondents found that they find AI quite useful for, it is said, research, data analysis, and document review. For what it's worth, I don't think AI is particularly good for research. So it'll be interesting to see what's the breakdown in this. But also, 51% respondents recognize the main obstacle in AI is the risk of errors and bias. I think that best frames this issue, right? Because while AI has been supremely helpful in preparing chronologies that are extracted from large documents, which you can use for your case preparation, it has helped us prepare really good summaries of arguments. When you feed in large memorials into it, it can tell you what the key arguments are. It has some very good specific uses. In fact, I think you could even give a pile of documents to AI and AI tools, for example, like relativity air, and it will be able to tell you that this particular document is pretty good for this claim over here, but it damages this other part of your claim. So it is good, but is it reliable? Is it foolproof? And the answer is no. We know about the risks of hallucination. We also know that regulators around the world do not like hallucinations, and they will penalize lawyers for it. And why is that? Because hallucinations undermine our public trust and confidence in the profession. So that's where we are. It will expedite processes. It will make some things faster. It will make it easier for us to have conversations with clients on, strategic, important issues quicker. But does it do away with the need of me and all of us sitting down with the documents and reviewing it just to be sure that it is correct? I don't think we are there yet. But with all things, paradigm shifting technology, I think I heard about the internet in the last panel, and maybe we are at that precipice right now. The S curve of this might be extremely exponential. And who knows, maybe 3 years from now, either we don't have the problem of hallucinations, or our professional regulations have somewhat changed, where the debate will be whether you as a lawyer did your due diligence in giving the right prompts to the system. And if so, then you're fine, even though the conclusion is not correct or accurate. But that's, crystal ball gazing, and my wagers don't really go right, so I won't do that. But I think, obviously, AI is here to stay. It's very much part of our ecosystem. It is part of our dispute processes and our workflow. All firms around the world are investing heavily in AI, including my firm. But with the caveat that all these policies say that there needs to be human agency behind it and human accountability behind it. Because if things go wrong, we need to understand where that went wrong.
I want to add something.
Yeah, sure.
So, there are two things, just very short. So, I've used AI only twice in my life, and there's some crisis of time. So, I asked AI for bilateral investment treaty and some import of that. And you know what AI comes out with? It's too complicated. I can't answer this question. The second thing I wanted to say is, in Singapore is the first country, I believe, where verification process by or credibility and verifying the same as being authentic and having verified the data was to be given by lawyers so that the lawyers are accountable. And I think it came in almost 3 to 4 years back, not now. So, I mean, this whole thing, and today I find AI is an answer to laziness, which bothers me. You ask for a question, nobody has a mind, they don't know what's going on in their mind. And punch in a couple of things and you can punch in and get a couple of answers. And that's put forward. Nobody knows what it means. Meaning is lost. So I'm quite lost with AI, actually. I feel that it's not going any far. Processes, documentation, summarizing, editing, though I believe my convent education gave me the best possible summarizing skills that can be required. So I do understand saving of time, standard formats and standard contracts, smart contracts, implementation. But it's got a limit. And definitely a human mind has to stay. We have to be around. You can't be kicked out like this with AI. So, and it's doubling work and tripling work at times. First, you get the data. First, you see which is authentic. Then you verify it. Then you go and re-verify it. I'm sorry, I don't know where it's going.
Well, I must share an experience. I am sure people have tried in their offices various things. So I got an award from a retired Supreme Court judge. So I told my office, listen, guys, put all the document submissions, everything into the AI tool and see what comes out. And the consensus was that it was a better written award. So this is just an experiment we did. And
but it is looking at something that a human mind has done. So you might have improved
no,
on it.
I didn't push the AI, the award. Minus the award, everything I put it in. And this is what it came out. And the consensus was the award was better written by AI. So these are some realities which are happening. So
I mean, but also it is better written because it's writing it in a way so that you like it.
Exactly.
Yeah.
Exactly.
So
It
is to
AI
please.
is to please.
Yeah, it is to please first and foremost.
Anyway, moving to a next topic, arbitration and mediation corridor collaboration. Iris, this question is to you. How do you think mediation could be used? We heard the earlier panel speak about it also more effectively in investor-state dispute settlement proceedings.
Thank you very much, Nusret, and good evening, everyone. I'll try to be short. I'd like to begin by asking everyone in this room a simple question. Could you please raise your hands if you would favor the use of mediation in investor-state dispute settlement? So interesting. So I can see only 3 or 4 hands. So we will.
I regret my decision.
Okay. We'll get back to I'll come back to the number. Well, let me share an experience grounded in my own practice. I act both for investors and states in investor-state proceedings. And what I observe on both sides of the table is a shared concern that arbitration is costly. It's public, the awards are publicized, and most importantly, it sometimes can be very protracted. It can take anywhere up to 3 to 4 years to get an award from registration of the request, and then you have the battle of the enforcement of the award. Let me be clear, I'm not here to debunk investor-state arbitration. It's my practice, and I think it remains essential for some disputes. Those disputes, for instance, that involve fundamental breaches from the state or a large-scale expropriation. However, I do believe that mediation has a role to play. For instance, those disputes that involve regulatory misinterpretation on the part on one of the sides, or delayed permits, or even those disputes which are still at an early stage, I believe may be resolved more efficiently, more confidentially, and at a far lower cost through mediation proceedings. The question is how we get there, right? And the good news is that the institutional architecture for mediation now exists. In 2022, as some of you might know, ICSID, the International Center for the Settlement of Disputes, revised their rules and regulations, and they adopted the first institutional mediation rules specifically dedicated for mediation. And I'd like to briefly explain what makes mediation in those ICSID rules different from what previously existed, which was conciliation. So the scope of mediation in those rules is very broad. Under the ICSID Convention, arbitration and conciliation is limited to those disputes that have a very high jurisdictional threshold. They require a dispute that must be legal, that must arise directly out of an investment, and that must involve a contracting state on one hand and a national of another contracting state on the other hand. As some of you may know, India is not a party to the ICSID Convention. But what's interesting in the ICSID mediation rules is that they sweep away those barriers. Now, ICSID can administer arbitrations that relate to an investment and that involve a state without any requirements in terms of nationality or in terms of that state being part to the ICSID Convention. So technically, if India would want to, they could mediate their disputes through the ICSID mediation rules. And remarkably, by not imposing a foreign nationality requirement, the ICSID mediation rules could even allow mediations between a host state and their own nationals. I wanted to briefly walk you through the mediation procedure, but I think a bit short of time. So I'll let you have a look at the rules if you find them interesting. But I think there are 2 things in these rules that I found particularly interesting. One of them is confidentiality. All the information and documents shared during those mediation proceedings are kept confidential.
even the fact that a mediation is happening in and of itself is confidential. Critically, no party may rely on any arguments or admissions that may have been made during those mediation proceedings in subsequent arbitration proceedings. So for states that may be worried about political scrutiny, or even investors that may be worried about reputational damage, I believe this is a very interesting procedure. And another point, because this was briefly touched upon in the previous panel, is enforcement, right? Well, what's also interesting about the ICSID mediation rules is that if the mediation is taking place in parallel with an arbitration, and if it succeeds, then the parties may request the tribunal to incorporate their agreement into a consent award, which would mean that then that award would benefit from the enforcement, extremely simplified enforcement regime of the ICSID Convention. But mediation faces real challenges, and those were also addressed in the previous panel. The most important one in the investor-state dispute settlement focus is political. Public officials may bear personal liability, and they require special authorization to enter into negotiation and those settlements. Just to give an example, in the case of SPP versus Egypt, the Egyptian prime minister had initially rejected a settlement offer in the amount of $10 million and preferred to go instead to arbitration because he considered that a settlement would open him to attacks by opponents and the media. Well, in the end, the arbitration proceeded, but a settlement was reached at a far higher cost of $17 million. So I think I'll just like to conclude with this. Mediation can offer a very powerful tool for a specific type of disputes, even in the investor-state framework. But what is needed is, I think, a few ingredients to make that work. The first one is political will. The second one, I would say, is training. We are not trained for that, and we are not that educated, so there will be a need for a culture of going to mediation instead of automatically going to arbitration. And the third one is protective measures to allow officials to negotiate without fear. And here I believe India is really well placed. As we heard before, India adopted a Mediation Act in 2023 and really wants to put itself as a hub for settlement of disputes. So I do believe India will have a major role to play in that respect. Thank you.
Thank you, Harris. Divyam, since we're talking about mediation, Chapter 29 of the India-UK Trade Agreement expressly provides for means of ADR, such as consular, consultation references on dispute panels. But at the same time, we have an office memorandum from our department, which was issued in 24, which restricts the scope of ADR in public procurement process. So where do you think how does this all end up? I mean, this is a big debated point, but for this audience, maybe you can enlighten.
Yeah, first of all, can you hear me? Yeah, thank you, first of all, BCLP for having me and General Counsel of Association of India as well. Before I delve into the question, let me echo what Iris mentioned about mediation. I'll quote, which will make Dr. Anand also happy, that ounce of mediation is worth pound of arbitration and ton of litigation. So that's the beauty of mediation. But whether it applies in every situation or not is something one has to see over a period of time. On this aspect, the morning started with hearing Chief Justice of India in one of the events, and he was unequivocal of the fact that arbitration has a very important role to play in our legal ecosystem. In fact, he went to the extent of saying that the courts acts as a co-partner to arbitration in India. We heard the Attorney General also echoing a similar sentiment, saying that arbitration, if there is consistency and clarity, it is something which is very important for development of economic ties. Its June memorandum, in that sense, acts as an anomaly, and it's gives a mixed signal where one end we are all promoting, saying, please arbitrate. And the June memorandum says, please don't arbitrate too much. So what is need to be seen is whether, of course, there is a difference between the CETA here, the trade agreement, because that applies in a case of a state and state dispute versus this office memorandum, which is applicable domestically to public procurement contracts. They don't operate in the same field. They may have an overlap in case if somebody decides from UK, the states decides to invest in India, possibly then there may be an overlap. But what we need to see is a mindset which needs to change. As I mentioned earlier in one of the panels, that there is a definite shift in the mindset of the judiciary. They are regularly pushing forth minimum judicial intervention. They are pushing forth public autonomy, competence. All those principles are echoed in India. From the fact that we have this administrative direction which has been followed by public procurement companies and PSUs in India, public sector undertakings, following such kind of a trend, my suggestion is that this needs to have a greater relook, because the signals which are being sent does not echo the sentiments which are there in this room, which has been the theme of our discussion, whether it is LIDW or whether it is the India IDR Week. We have always been championing this cause. And Karthik mentioned about Queen Mary survey. In that same survey, London is ranked as #1 arbitration hub in the world. The only city in India that finds mention is New Delhi, and that is ranked at 20. There are, and when the survey, you look at the percentage, 34% surveyors supported arbitration hub of London, and there are only 2% which referred to in New Delhi as an arbitration hub. But that, of course, has changed because the surveys of 2025, 2021 similar survey, New Delhi was not even there in the picture. So we are improving. There is an incremental improvement, but not transformational. And what I suggest again is that 3 C's. There has to be consistency, clarity, and certainty. And once we are able to achieve that, I think we'll follow the footsteps of UK, and it will also help in improving the trade relationship between the two countries.
Yeah, I think he was saying something.
Very small comment. I think our arbitration ecosystem in the world needs a relook, but India needs it even more right now. We don't need a greater relook on the circular. We need this out. Because actually it's not mixed signals, it's a negative signal. When we are promoting something, we can't on one hand say that over 10 crores you don't have arbitration. Whatever the reasons are, there are reasons behind it, but I don't want to discuss that part of it. We've come a long way. We have to rebuild the confidence, A. Secondly, what we have to do in India, and which we are trying, by the way, some amendment process is yet underway, which is still being thought about, is to actually fast circuit the process of adjudication. We have to reduce the tiers of litigation that are there in India post-arbitration award, which would help tremendously in making the process more efficient. India is also concentrating on ad hoc arbitrations. We need to shift it away back to institutional. Because I do believe over the world, I mean, the experience has shown institutional arbitration has a leverage which ad hoc arbitration can never have. So with all these things, and finally, on the line of mediation, India is promoting, for example, mediation tremendously. We've had, at the nationwide level, we've had 2 conferences, one in Delhi, one in Orissa, which led this story forward. But there are some problems in that, A. Having said that, the hybrid mechanism that we've been talking about in the morning also, Devim was also there. The hybrid Medaloya, there are some arrangements between Singapore Mediation Center and Shenzhen Court, which is a Chinese court, where you have a mediation done in Singapore SIMC and then have the award made in Shenzhen. I mean, these are some of the possible solutions. Standalone by itself, we don't know how much it might work because there is a limitation. Investor state, to my belief, not. Sorry, Ira. I really don't know how it can work in investor state, because when states become involved, whether it's domestic, investors treaty, mediations cannot work because states do not give the sanction to do the necessary process. You will hold it back. And I found it in various levels at, when we've confronted with this on any decision-making process, because the state will take the decision and the state will not permit any officers to really negotiate to a level. And this is sovereignty we are talking about. So I have a slight caveat on investor state. But as I said, I have full confidence that mediation itself has been largely successful in a lot of domains and in a hybrid system. So we must carry on with that process and amplify it as much as we can.
Iris, you want to say a few words on that?
Sure, I believe if the states have the required authority to conduct arbitration proceedings, then they might, even in state entities in commercial arbitrations, they might be able to also have the required authority to empower some of their officials to go and mediate. I really think it's a cultural point. We are not used to seeing mediation in investor-state proceedings now. So, and this might change, I believe, over the years. If you think about concerns about time, cost, publicity, think about the confidential nature of those mediation proceedings. That might be of interest to some states. Just raising this is an open question also for the audience.
So we all
hope should be high.
Yeah, hope so. We're almost out of time, but we have about 5 minutes. There are.
I think that we can conclude now.
We can conclude. So that's it. The boss says conclude. Thank you very much. A big round of applause for the panelists. Thank you.
So may I request now, Mr. Brett Dixon, the Vice President of Law Society of England and Wales, to say a few words and to conclude the whole discussion, what we had in the last session.
Good evening, everybody. It falls to me to bring you towards the end of the day. It's been a long day. Mine started around about 9 o'clock, talking at the arbitration event. I've had the pleasure in between of hosting an admission ceremony at the Law Society. So you see all of these new people coming into the profession, full of joy and unaware of all of the different debates that we are having around here. And what you can say about that, though, is that they will bring a new perspective. That's probably one of the most important lessons I've learned, having a moment out of some of these more higher level discussions. But those of you that don't know me, thank you very much for the invitation and thank you for the very kind introduction. My name's Brett Dixon. I'm the Vice President of the Law Society of England and Wales. The other thing is that I will be President in October of this year. Now, if you think about civil litigation, arbitration, or maybe even sometimes mediation, that's one of those deadlines you can't move because nobody will ever allow you to do that. So he's coming for me come what may. But we are a representative body for roughly 210,000 solicitors qualified to practice English and Welsh law. And about 10,000 of our members are based overseas. And it is a great pleasure to join you here in London today and welcome you to the reception that will be hosted by the General Counsels Association of India, which brings together colleagues and friends from across the UK-India legal community. I hope you've enjoyed the conference earlier this afternoon and on into the evening. But let me begin by just expressing my thanks again to the founding members of the General Counsels Association of India, Dr. Sanjeev Yemawat and Dr. Akhil Prasad, colleagues, for convening today's discussions and for bringing us together this evening. Events like this are incredibly important, not just for exchanging views, but also for strengthening the relationships that underpin the UK-India legal partnership. And that partnership, well, it's never been more important. As trade and investment between our two countries continue to grow, so does the need for strong, trusted legal frameworks that support businesses, enable investment, and provide confidence in an increasingly complex world. That is where the international legal community plays such a critical role. I want to take a moment just to recognise the leadership of the GCAI. General counsels are central to business decision-making, navigating risk, shaping strategy. and guiding organisations through cross-border challenges. We know from our own work here in England and Wales that in-house legal advisors are the fastest growing section of our membership. You occupy a valuable space within businesses and other organisations. You provide strategic guidance, staying true to our professional values. Through its growing network and influence, the GCAI is making an important contribution to strengthening the general counsel community in India. We at the Law Society of England and Wales very much value the opportunity to strengthen our bonds with you. The Law Society's current president, Mark Evans, recently travelled to New Delhi, where we were delighted to meet the founding members of the GCAI. What was clear from those conversations, and the conversations I've had with Mark since, being the person who will ultimately be responsible for taking over the reins, is that there is a strong shared commitment to deepening collaboration between our professions. And that collaboration is particularly important as we look at developments in the legal services landscape. I'm sure you will all be aware of the Bar Council of India's decision in May last year to implement regulations allowing foreign lawyers and law firms to practice in India. We welcome this development. This marks a significant and a positive step forward in opening up the legal sector, and this has the potential to unlock new opportunities for lawyers and businesses in both of our countries. Of course, as with any reform, there are practical questions that still remain, and our continued dialogue will be key to ensuring the framework works in practice for the benefit of all of the stakeholders involved. But the overall direction of travel is encouraging. From our perspective, openness in legal services brings clear benefits. The UK is and will continue to be an open jurisdiction for legal services. Our legal sector allows international lawyers, including those from India, to practice, to establish themselves, and to work alongside UK qualified lawyers. And we see the everyday value that that brings. The UK legal sector benefits greatly from the skills, expertise, and global perspectives that international lawyers contribute to our profession and work. It enhances consumer choice, improves business outcomes, and supports inward investment. More broadly, our experience here in the UK has shown that an open and collaborative legal services environment does not weaken our domestic capability, it strengthens it. It enhances a jurisdiction's attractiveness as a global centre for legal services, dispute resolution, and commercial activity. We see real value in strengthening the connections between our legal communities, particularly from the perspective of businesses and organisations that the General Counsel supports. For in-house lawyers, the ability to navigate cross-border matters effectively is increasingly important, whether in managing risk, supporting investment decisions, or enabling international growth. Closer engagement between our professions can help share insight, experiences, practical approaches to these challenges in a way that supports general counsels and the organisations that they serve. Above all, we are keen to listen, to learn from your experience, to deepen our engagement with the wider legal community in India. Events like this, and don't worry, I am nearly done if you're thinking about what is outside the other side of that door, they provide the perfect opportunity to continue those conversations. That's the other side of the door, keeping with the theme. I would encourage you all this evening, take the time to connect, to exchange ideas, to build the relationships that will shape the future of our shared legal landscape. Let me close by once again thanking the GCAI for bringing us together The UK-India legal relationship is already strong, but there is much more we can achieve together. The Law Society of England and Wales stands ready to work with all of you, support that journey through dialogue, collaboration, and a shared ambition for the future. Thank you. I hope you enjoy the rest of this evening. Of course, it's the other side of the match. Thank you very much.
So next, let me thank you very much. Just before we conclude, just.
Becoming brief. What time is that? Quite cool.
Ready? Thank you.
Thank you very much. A feeling of absolute gratitude to all of you for sparing time for this marvelous discussion. And before we can now just go for the evening drinks, I think. But then before that, a photograph.
Yes.
Thank you very much. Thanks a lot.
If anybody wants any help,
You a lot, I know that.
Yeah.
Please don't worry. It's not at all. Nice to see you.
But good to see you.
It was fantastic. You did such a good job. Congratulations. I'm not sure. I don't get your watch. You do? Yes. That's right. I mean, we talk a lot about you and a lot about you. I'm based in London. Yes. So I'm going to come to the
Pinky,
yes. Sorry. Sorry. I just come. This side. Yes.
Yes.
Just come this side.
Yes, please do. Pass it through the international team and we will.
It's fine. Perfect. Thank you very much. Thank you very
Maybe one day we'll together at the same table.
It's very good conference. Nothing today has run even close to time.
Thank you so much. So you will be based on election of the government of India, on the representation.
Thank you so much.
So nice of you. Thank you.
Sorry.